What is a
My lord,
is a recovery from a retirement dues as overdrawn?
retirement dues that has been objected to, my lord, that against that the
Now tell me what is the law? You know the judgment of the Supreme Court, at least 3 or 4.
Latest judgment on a special bench. Rafik Masik case. Your lordship also
Rafiq
dealt.
Mashi was the Supreme Court judgment. That's
Yes, yes.
and now special bench.
my lord, one thing, my lord, this as I have, my lord, gone through one of the, my lord, the appeal grounds which has been taken, the only ground which has been taken, probably, is that, my lord, depending upon a judgment passed by the Honorable Supreme Court in Chandi Prasad Unnayal case. My lord, that is, lord, that exceeds the judgment. This is the only point.
I think the principles which is applicable in this is that if the government or the employer of his own has given certain benefits, financial benefits, he has not committed any fraud, nor misrepresentation, nor any false information, then in that event, at the fag end of his service career, you are deducting the whole amount for which he was not responsible. You extended.
Yes, yes. That's
the principle.
Principle.
Which is there. How can you do it?
And behind back, they had deducted without any notice. After retirement.
That is not.
No.
Notice, my lord, this has been objected to by the Director of Pension, my lord.
Sir, when you extended it, then how? At the time of the back end of his service career?
Yes.
Show us the judgment, let us see, and where is the recent judgments? We give that. Rafiq Masih was considered here.
Lordship, Chandi Prasad Union also deal with that judgment.
Has it considered the Rafiq Masih case?
My lord,
tell us.
Here, my lord, the only thing which has been stated, that is for the, my lord, it is a taxpayer money and that should not be.
No, that can't be.
Lord, the initial fixation was wrong because my lord, he is a craftsman.
Why you did not detect it? Why? This initial fixation must be a decade ago.
At the time when he joined, because
at the time of at least a decade ago, 10 years of continuous service is the entitlement for pension. So at least I can say a decade before what you were doing for more than 10 years.
That's 33 years. Qualifying salary. Minimum.
Qualifying.
What you were doing?
That was not detected. That was, my lord, only detected.
And the Rafiq Masih, where is that? Rafiq Masih's judgment? And where is the judgment of this court? Special bench, you said?
And special bench, and Rafiq Masih in a 3 judges bench.
3 judges.
Thereafter, here there is no special bench in our High Court.
So Rafiq Masih, what is the citation?
And lordship.
और अच्छे यार, ये नहीं है.
2000.
It's a 2-judge bench. 3-judge bench will have a primacy over it. Mr. Towell, you should come prepared. You are an officer of the court first. Then you are representing your client. If you find that the 3-judge bench has held, then how can you rely upon a 2-judge bench decision?
This is the only decision we have also, my lord.
Because you do not have. I am told by young age, by Mr. S.P. Raichodhuri, that think of any weird proposition of law, any point, go and search in the AIR manual. You will find one thing. Is appropriate. Found one judgment that you did not apply your mind whether this judgment is still a good law. In view of a 3-judge bench decision, this is a 2-judge bench decision.
Overdraft,
But it is
overdraft.
after Rafik Masih because yes, this is
Traffic
matlab
policy has not been considered, then it's a per incurium judgment. It's not considered, has not considered Rafiq Masih. And secondly, it cannot take a deviating view.
বলছি দেখতে হবে
Or
সাতটা
another judgment which has been considered.
Abdul Qadir was earlier, I know.
Abdul Qadir has been.
I know.
Yes.
But Rafiq Masih is the three judge.
লর্ডশিপ
Matlab,
তুমি তো বলিস
Sir, why are you not coming ready with that?
লর্ডশিপ may I submit lordship first of all the we could not contact my client. That is, no, lordship. Beeb is not with me. That lordship kindly 2 p.m. I shall lordship online search করলে পেয়ে যাবো। আছি আমি নিয়ে এলে কি আবার দাঁড়াবে এখনই মারলে চলে আসবে। তো একটা ছিল আমার কাছে এই টিপটা ঠিক আছে এই হিন্দি প্রচুর করেছি রে বাবা আমার কাছে কিছু কিছু এখানে ছিল
পেয়েছিস আব্দুল কাদির তো এখানে কনসিডার করছে আব্দুল কাদির
কাদির না পরে কাদির হয়ে শেষ হয়ে তারপরে এসছে
Well, two citations has been forwarded. One is 2004 14 8 SCC 883.
What?
Another is Milord 2015 4 SCC 334.
Rafiq Bashi.
Rafiq Mashi.
তারপর তো 15 এর হবে
15.
15 4 SCC 334.
Start 15.
This is Milord 15 is two judges bench. It's two.
তাদের কালি কালি
নেই না এখানে আশ্চর্য
ওইটাই আমার সেইটা বইটা নিয়ে এলে কোথায় যাবে?
ঠিক আছে
দিলে ওটাই দিলেই হবে। ও আব্দুল দিয়েছে
ঠিক আছে
আমার কাছে ছিল আসলে এই এতে পাচ্ছি না।
এইটা কিন্তু নিয়ে আসতে বল
No, the case here,
Milord,
because of a high scale of pay.
no not higher scale. It was from the initial stage, my lord. He was a crafts teacher and he is not entitled to the amount, my lord, the scale which has been given to him. That is the, my lord, objection. My lord, my lord kindly sees the page 5 ground 3. That is the, my lord, the objection. This is his next higher scale is 440 with 1070. His pay was fixed at 520.
So that is a high scale of pay. That was erroneously fixed.
It was fixed from the very beginning, my lord. He was not entitled to, my lord, 425. He was entitled to 300 to 685. But he was wrongly given, my lord, 425 to 550. 1050. That was from the very initial stage. Thereafter, my lord, career advancement scheme was also given on that. So entire, my lord, club to the amount which
Yes,
has been, my lord, tried to be.
Entire lateral benefit subsumed into that excess provision.
Yes.
Entire. He went out with an empty hand. So he served the institution for such a long time. Look at the realities of life. If a person earns,
Recovery was
it's for a human being. You cannot divorce yourself from the society. As a part of the society. A lawyer.
Fine.
If the earning is 100 rupees a month, then at least he spends 40 to 50 rupees for his sustenance. There are some more amenities. 30 rupees he saves. And the 20 rupees he spends for some good reasons. Apart from the basic necessity. And if he is earning 80 rupees, then you reduce that minimum bare necessity to 40 rupees. The moment your income increases, your expenditure also increases.
also
You may be roaming around in a bicycle, motorbike at the first stage of your career. Later on, now you are roaming around in a Mercedes or because your earning has gone up. So naturally, the expenditure has also gone up. What the poor man will do? From where he will give?
my lord, this is the only point taken by that.
He should be benevolent. He's a nodal employer.
My lord, এই বইটা দেখো 15/4 334 334 এই রফিক মাসিক জাজমেন্টের সাইটেশন বল
আরে এটা ধরবে গো।
জাজমেন্টের সাইটেশন আছে রফিক মাসিক টু জাজেস বেঞ্চটাই আছে পাঠিয়েছি ধর
মুশকিল তেরো।
What that judgment itself is a guiding factor.
পেয়ে গেছে ও
হুম
হ্যাঁ টাকা পেয়ে গেছে
হুম
as per my
তারা তারা বলে দিই। ফুট ফুট ফুট। এটা তো বলে দিয়েছি আমি।
পয়সা পেয়ে গেছিস তো
হ্যাঁ আমি কবে 19 সাল সেই সেই সময়
দিয়ে 13
তেরোতে যেই ওই সময় খেয়ে নিয়েছি। বারো তেরোতে। নম্বর কেমন সার্চ করি
should cite a judgment after going through the same meticulously.
My lord, that is, my lord, the only point.
No, have you seen the judgment?
Yes, my lord, I have. Only we have relied on paragraph 14.
Sir, you can't. The judgment has to be read as a whole. Come to paragraph 3 of the judgment. Placetum C. What it says.
The learned counsel placing reliance on the judgment of this court is
Akara was what? Correctly exercised after having found that the payments were affected due to wrong fixation of the pay scale. Your case is the same. And this court under Article 2 shall not interfere with the direction exercise. Reliance was also placed on another judgment and the court granted the relief. Means in Akara also the granted the relief that you can't recover. Then come to paragraph 15. You are relying on 14. I am giving you a 15. We are therefore of the considered opinion that except the few instances pointed out in Abdul Qadir and Akara, the excess payment can be recovered. So if it comes under Akara, you can't. That goes against you.
I have gone through it, my lord.
What more? That's why I say you have to be careful in citing a judgment. Yes, come. The
See,
short
one
point,
thing, my lord, he has already got the money also. Money has been released.
ট্রায়াল কোর্ট
short
জাজমেন্ট
point,
কমপ্লিট
the short point involved in the instant appeal
আর দেখিলাম
is whether an excess amount paid to the respondent employee can be recovered after can be recovered from the retirement dues. Stop. The opposite point came up for consideration. In many cases, which reached to the apex court, and opinions have been expressed thereupon. Stop. One line of cases. Now, one line of cases based upon Shambabu Verma versus Union of India within bracket 1994, volume 2, SSC 521, have laid down that if the excess amount is paid to the employee voluntarily by the employer and there is no element of fraud, misrepresentation, and or wrong information at the behest of the employee, the excess amount cannot be recovered from the retirement benefits. The said principles was subsequently reiterated in a subsequent judgment of the apex court rendered in Colonel B.J. Akara versus Government of India, reported in 2006, volume 11, SCC 709, wherein the excess amount was paid for wrong fixation of pay scale.
17.
And in such backdrop, it was held that a person cannot be saddled with any liability to refund the amount from the retirement dues.
Interest হয়ে গেছে
6% কি ছিল ওটা কমপ্লিট করেছি তো মনে নেই
However, a strong reliance is placed upon strong reliance is placed by the appellant upon the judgment, a two-judge bench decision of the Supreme Court in Chandi Prakash Unyal and others versus State of Uttarakhand and others, reported in 2012, volume 8, SSC, page 417. For the proposition that the mistake committed by the employer is not immune from being corrected, and therefore the excess payment can be recovered from the retirement benefits. It is succinctly observed that the government is dealing with the public money, more particularly the taxpayer money, which neither belongs to it nor to its officer, and therefore the burden on the public exchequer shall not be allowed to be perpetuated. Taking a liberal view, I know Justice Datta has discarded this. I'm conscious. There is one judgment of Justice Datta who has discarded this. একটা rules আছে সেটা Justice Dipankar Datta একদম discard করেছে।
হ্যাঁ,
Anyhow, even in Chandi Prasad Unia Supra, the apex court has not laid down a universal application of the law that in every conceivable circumstances, the recovery is permissible from the retirement benefits. Though the two-judge bench of the apex court in Chandi Prasad Unyal took note of a three-judge bench decision, the earlier three-judge bench decision rendered in Shambabu Verma Supra, but held that the said judgment applies in a special facts of the said case.
itself.
So the bench delivering a judgment, no, we will not. Delivering a judgment in Chandi Prasad Unia Supra, were conscious that the larger quorum bench decision is binding on a lesser quorum bench decision, binding upon a lesser quorum bench or the coordinate bench, and therefore categorically observed that the law laid down therein would be applicable to the situation which do not come within the instances on which the said Abdul Qadir case as well as the BK Akara case were decided. We noticed from paragraph ওটা আব্দুল কাদের কেসটা যেটা আছে ওটা তোমার হচ্ছে আমি তোমাকে বলে দিচ্ছি 2009 volume 3 SSC 475 ঠিক আছে
Paragraph 12, it has dealt with. Paragraph 12.
What?
Under Abdul Qadir's case has been dealt with.
No, I know it. কি বলেছি and Colonel
Are
B.J.
open?
Ankara, Supra, correct case, was decided in the following bole, paragraph 15. I have seen the judgment, sir. You should be careful while citing because that goes to his favor.
favor.
Quote paragraph 15. No,
Okay.
15 or Chandi Prakash. দিয়েছি আগে, দিয়েছি। It is sought to be contended by the appellant that from the very inception, there was a wrong fixation of scale of pay which do not come within the purview of the Abdul Qadir's case, which was in relation to a grant of the higher scale of pay. But we noticed from paragraph 3 of the said report that the case of Colonel B.K. Akara was exactly on the same principle. That is, the wrong fixation of scale of pay, and the recovery was sought at the fag end of the service carrier. Stop. In view of the observations made in paragraph 15 in Chandi Prakash Unyal, any instances which comes within the ambit of Sayyid Abdul Qadir and Colonel B.J. Akara, those would be outside the purview of the said judgment. Since the instant case comes within the strict folds of the facts involved in Colonel B.K. Akara, the law laid down in Chandi Prakash Unyal is not applicable, or rather goes in favor of the respondent. In such view of the matter, we do not find any illegality and or infirmity in the impugned order. The appeal is dismissed with cost.
My lord, 2013.
Yes, no cost.
The 13 matter, my lord, and I have been told that that has been already complied with.
At that point of time, complete हुई loss. Trial court-
Everything has been
Every-
complied with.
Lordship, all trial court
So
judgment.
you should be very careful when you cite a judgment.
আমার
I have a bad habit. I am groomed in a sarista where my senior has told that every judge. What by who's expected?
grateful.
At number 4,
What the? Well, I'm for the appellate.
Well, I am for the respondent number 4.
4.
4.
I'm from the respondent
There are
1 to
other
3.
one and two.
1 to 3. 1 to 3. West Bengal University of Health Sciences.
1, 2, and 3.
Three.
4 you are.
My lord, private respondent.
There any other response?
No.
No.
First, well, I think your lordships can dispose of the appeal here now,
Here and now.
because all the materials are before your lordships. And that was the intention, my lord. That's why affidavits were called for.
But we have to deliver a judgment by application of right.
And I think your lordships will need not much time.
No application of right.
Application of mind always, my lord.
but not, it will take much time because I am languishing before the court. Kindly have a look at the
For
judgment.
one reason, because there are at least 10 CAB in the last week.
That's a lot. Out of that, 4, 5 of mine.
We have to deliver it. We are taking up everything, but that's why we do not want to burden our system. If it requires small matters, simple dictation here and now,
A very short point involved. That much I can tell you, losses. Let us at least try your losses because the stay application. Because
what is the matter? First thinking, what is the
matter your losses, this is in relation to promotion from the post of demonstrator to the assistant professor. Now there was an invitation of applications from the institute amongst the candidates, amongst the teachers. Now there is a cut-off date, 26 June. Within this, you have to qualify yourself for promotion. Now, I myself, the petitioner and others, they had the qualification.
they have cancelled the entire promotion.
No.
Why the disclaimer is quoted?
No, that's my lord. I don't. That's my point before your losses. That how can the single judge take that disclaimer point? I know, my lord. I couldn't follow.
Disclaimer is required. Suppose if the authority later on decided to cancel the entire
No, not at all. Not at all.
process.
Learned single judge, as I have understood, in the advertisement there was a disclaimer clause. Learned single judge has pointed out that there was a disclaimer clause. They could have, but that's not the point.
Yes.
No, may I take your losses the facts so that your losses can quickly do it? If your losses kindly take up my learned friend's affidavit in opposition, private respondent. I have, but one application is also there so that I can chronologically place it. That I cannot have. He has disclosed it here. That's why I'm telling. All in my application, your losses will have it. Then let me proceed with my application. I take your losses. Now, kindly first look page 77, the advertise or the notice inviting applications. This is of 11th June 2018. Applications are invited from eligible faculty members, regular or permanent appointment, for promotion to higher academic post of professor, associate professor, assistant professor in different disciplines of modern medicine in the college. The West Bengal University of Health Sciences, Kollam. We are concerned with Department Physiology. Kindly level Professor 1, Associate Professor 1, Assistant Professor 1. This is the vacancy disclosed. We are concerned with Assistant Professor, Department Physiology. Within bracket, capital R denotes your losses. At the bottom, R means resultant vacancy. That means, my lord, Assistant Professor someone was holding. He has been promoted to the Associate Professor. Therefore, this is the resultant vacancy. Now, your losses, the next page, page 78. Applications duly filled in the prescribed format forwarded by the concerned head of the department are to be submitted to the office of the principal of College of Medicine, JM such and such, by 26 June 2018. The principal thereafter shall forward this application to the professor of the register such and such. Well, I tell you, losses for promotion, one has to have the MD in physiology. That was the qualification. Now, the last column your losses will find the disclaimer. Reserve the right to cancel the entire process of recruitment, panel, or appointment. This is the disclaimer. Now, your losses, cuts of the matter, kindly take up the private respondent's affidavit, his application. That's why I was wanted to place it. Page 37. But kindly see the prayer to the registrar of the university. Prayer for departmental promotion from demonstrator. This is
8th June or 26th June.
At the bottom, you'll also find 31st July. This was received or verified.
Yeah, 31st July.
At the bottom, verified note SC candidate.
That is a different, but later date is
Later dated, June, my lord, is no date I do not find, my lord. 25th June. My lord, they received your lordship 25th June. My lord, seal of the university. Now, your lordship kindly see the content of it. This is
16. Yes, then
now kindly see the content. This is for kind information that I, Dr. Bhaskar Saha, have been working as demonstrator in the department since 1st December 2009. According to the notification dated 11th June 2018, I am applying for promotion for demonstrator to assistant professor in the same department. My MD physiology theory examination is over. Viva practical examination will be held on 3rd or 4th July 2018. Hopefully, result will be published soon. Therefore, he is applying, my lord, at the best, my lord, 25th June. My lord, kindly consider page 56 of this affidavit. These also, your lordships, at the bottom I find all the notes and the application date 56. 5/6 month. Kindly see the content. This is to inform that I could not submit my complete final result issued by Ranchi University at the time of applying for the post of assistant professor. Malad, therefore, on 25th June itself, the other application says I am applying. Department of Philosophy hence request you to grant me opportunity.
given that on 25th June,
And the earlier application also 25th June.
that was received on 25th. Must be at written on 16th June.
Malad, I didn't get it.
That is what submitted. And he is submitting later on.
No, what he says, Malad, kindly see. Grant me opportunity to submit. I therefore undertake to submit the original complete final result certificate at the time of interview. Without fail, else or my candidature will be. Then your losses kindly see application of Saha may be accepted with the permission.
Oh.
With the permission of the Honorable VC on condition that he will, I can't read it, Malad, his pass certificate will be submitted before.
Every pass certificate.
Every pass certificate will be submitted before interview.
Correct.
Now, your losses, the first contention was that, therefore, by the last date, he was not qualified. 26 June, he was not qualified. Now, after this, kindly see which order was passed by the authority. My lord, at page, my lord.
Where is the eligibility criteria that he should be MD on the date to us, because it does not say, you say so. Only thing is eligibility criteria as per the, as per the rules and regulation of the Medical Council of India.
Exactly. Well, that says MD. This is undisputed, my lord. This is undisputed. I accept, they accept. MD is the basic qualification for promotion to assistant professor. Now, kindly look at the order passed by the authority, because I came before this honorable court.
Only a very good friend of yours. In your client,
My lord.
I know, but your client was a very good friend of.
Not at the same against same notification, my lord, in the year,
Very good friend.
not,
Comes with the same knowledge as you.
working there since 2009.
They are working together.
Yes, as
They
demonstrated.
are good friend. Because the biggest enemy is the good friend.
And he is working, my lord, as assistant professor since 9th of October 2018. This is the second round of litigation, my lord, this date application.
See something, that's why I asked.
Now, kindly see the order impugned in the writ petition at page 98. Well, that's not the only point. There are other
What
points.
criteria we wanted to look at? What is the MCI criteria?
Well, that's that I give you. And I thought about this is undisputed, that's why I didn't bring that copy. Watch it. Oh, they have. Duto copy. This month your losses kindly come to the schedule 1, third page, schedule 1. Assistant professor in the column.
Regulation.
UGC regular, okay, undisputed. A postgraduate qualification MD or MS in the concerned subject. Here, physiology.
Yes, what do you say? Which one?
Assistant professor. Has you also got that one within the column? Last. A postgraduate qualification MD, MS in the concerned subject.
Which one? Which one? I was reading something else because you will not take us to that. That's why I was.
Schedule 1. Now, qualification MD or MS for assistant professor. Now your losses can look at the impugned order. Page 98.
Forget about it. Now, get your point. We are the first appellate court. We will everything is that written now. Into the what? We can substitute our own finding. Don't worry. What is your point?
My first point, I stood first in the interview, according to number, but I have not been appointed.
Only in the interview.
Only the interview was there.
What was there is no other criteria.
No other criteria.
Why you were not appointed?
I beg losses?
Why you were not
I tell you losses. Second point, that he didn't qualify within the time limit of the advertisement or notification.
We will take care of that.
And third, your lordships, if it is, my lord,
First point you elaborate.
first,
First the interview, why you were not appointed?
my lord, I was subsequently came to know, they say that the post is reserved.
So according to you, this denotes resultant vacancy, but they have treated this R as a result.
No, they have not said it. That's why I'm trying to kindly have a look at the impugned order. They never said it. They never said it even reserved. Kindly have a look at
From
this.
where you got it a result?
Subsequently, when they filed the writ application, they, in the appeal court, says this is reserved. Even not before the single judge.
Court where?
When the first it was taken up. Then affidavit was called for.
They must have said here also.
Here also.
So
And that's your losses. Kindly have a look at this.
show us that this R denotes resultant vacancy, not the reserve vacancy.
Well, that's your lordship's advertisement itself.
Advertisement does not talk about anything.
Yes, says it.
Because I do not find that it is reserved or resultant
My
vacancy.
page 77.
I do not find anything.
I'm similar. Kindly see within bracket R.
Oh, Mr. Sanyal, do you think we are so dumb?
No, I have drawn. You also kindly see the bottom.
Please consider. If you see, please open the shutter of your mind, kindly try to understand. This R denotes something. According to you, this R denotes resultant vacancy. That's your interpretation.
No, at the bottom they have written.
What?
Well, at the bottom, R means resultant vacancy.
So that.
That I've shown to
That
you,
is
but
why-
probably I've missed it, your losses. Kindly have a look at this. R means resultant vacancy.
Correct.
So they now say this is reserved. And how could it be reserved unless it is declared? I stood first.
But they explained that this resultant vacancy arose because it was a reserved category. The person has been promoted to a higher scale. It was actually a
Well, I take your
vacancy,
losses to their
resultant
affidavit.
vacancy of a reserved category.
Well, I take your, then other candidates should not have been called for the promotion. If it is a single post reservation, vacancy 1, if I am a general candidate, why have you called me? So this was not declared to be reserved. Then the losses can level look at this. Their
They
affidavit.
have said reserved
Their affidavit.
towards which paragraph?
I tell you. Loss. Page 3, capital C, paragraph. The answering respondent on June 11, 2028 through a notification bearing number applications were invited from the eligible faculty members for promotion to higher academic post of professor, associate professor, assistant professor in different disciplines of modern medicine in JNMH Kolani. In the said notification, application invited as per 50-point roster. It never says so. The 50-point roster. Only say the act will applicable. Then if the 50-point roster, as your lawsuits knows, 50-point roster means promotional roster. So the general candidate should not have been taken interview at all. Reserve category post in physiology department along with other posts in the other departments. The last date for filing application was declared 26 June 2018. The notification also affirmed that the reservation policy as per sections 4 of the Act and Scheduled Tribes will be followed. Then your losses kindly see. The petitioner with the respondent number 4 applied for the post of philosophy as per the notification. It is pertinent to mention the appellant belongs to unreserved category and the respondent number 4 belong to SC, physical disabled category. On such and such, the answering respondent declared the date of interview 31st July 2018. As per the application dated 11th June 2018, the appellant was not eligible for the post of professor due to unreserved category. Now for the first time they disclose it. I'll show the result. Kindly have a look at the result. Kindly 105 of the stay application. Page 105 of the application. Then again I will take you to their affidavit.
Yes.
105. The interview broadsheet. Page 105 of the stay application.
Dot point. Last 45 minutes.
Last
45
today I have not taken. No, 45 minutes probably I have not. But kindly see your losses. My lord, Malad, they have written like Malad, as we sign Ukalatnama, Dr. Bhaskar Vishwas first, Bhaskar Saha, Dr. Jyotirmoy Vishwas,
Right?
Ah.
Oh, acha, this is at the top.
and the
Saha is you.
no, Saha is Mrs. Nondi's client.
He got 6.9.
No, at the bottom, he got total 57.1.
Yes.
Ah.
And you are?
I the last, Dr. Arpan Kumar Ghosh, 69.
Oh,
Now this is the Malad. After this was done, they say like this. Now I will take a losses to how can it be Malad resolved. কোথায় বলে? Page.
oh, you attended many conferences.
Available?
You attended many conferences.
And that's there according to the system, whatever. Now your losses kindly, I request your losses kindly see the impugned order, which was challenged before the writ petition. This has a bearing in losses. Kindly have a look at it.
Okay. Suppose if you are the only point is, they, according to you, they did not indicate in this particular notification that this particular post is reserved for a particular category. Rather, it was for the resultant vacancy, open resultant vacancy, everybody can participate. And how to be participated? Thereafter, once you stood first, how can you be spared after the result is declared on the ground that it was really kept for a reserve category? That's your point.
No, this was never kept. Now this, I tell you losses, I use the language, this is tailor-made.
What I say is that after the result is declared,
They say that. But I, Malad,
my English is very bad. I think.
Malad, I always find with your losses, I join with some quarreling or like that. I don't know Malad, why this happens. Somehow.
Another gentleman like this, that is Mr. Ghosh in the parliament. What we have argued, if Bench repeats that what you have argued, he will always say no.
Malad, I tell you losses, I want to do this little.
What he want to say in his own language, then I always say my language is so poor. I am so bad in English. What can be done? I can't match with you peoples.
Now, I tell you losses,
That's the
crux of the matter.
That's the sum and substance. Your only point is that in absence of any indication at the time of an advertisement that this particular post is kept for a reserve category. Later on, after you are adjudged as the first candidate, the top candidate, they cannot keep you outside the zone of appointment and then say that it is for reserve category.
Malad, I little add it. Malad, because I should, I think. They allowed a candidate who didn't become qualified within the time, admittedly.
Was coming later.
Now, I'm what I'm trying to say, let me.
What I'm saying, that is what it is the first point. Second point says that even a first point, suppose a first point fails, then also you have a second line of attack saying that as on the date of as on the last date of submission of an application, admittedly, private respondent who have been promoted to that post did not have the MD degree because he appeared in third or fourth, whatever, that semester, and the result was awaited. So, according to you, the law is that as on the last date of submission of an application, he must possess the MD qualification.
That's a settled law, Malad.
Settled law.
Now, all
Just see whether it can be unsettled.
That's another aspect. Now I tell you, Lordship, the third and fourth point. Third, I tell you, Lordships, they wanted to select this person all throughout. Why I'm telling you? That's why this is tailor-made. They first allowed beyond the date. They thought it that he will qualify in the interview. They will somehow, the management thought that they will somehow manage it. When interview hold, they could see that they could not manage it. Someone else get it. Now then they say this is a reserve post. Kindly, Malad, I am placing like this. Now the third I am showing, Malad, that's your Lordships, as I find from the fact. Because otherwise they could have said it.
The other side of the coin.
Yes.
If they have a predetermined mind that they will choose this candidate, there was no occasion that the interview board will give you highest marks than any other candidate.
Malad, they had no option. They had no option because your Lordships, the category was there. This is only oral. Had it been oral, your Lordships, it could have been. Had it been oral. I tell you, Lordships, the other thing, there are. No, Malad, there are certain things. Oral, but there are certain criteria how to be marks to be given.
No, I am talking about the marks. Say oral is 15 marks. Other marks, forget about it. Everybody was nearer. You got 58. Selected candidate got 47.
It's not nearer, Malad.
How much? 11.
That's enough, Malad.
Huh?
Not.
Been a 3 marks in an interview out of 50. Who is going to say? And he got 15 marks in the interview. Who is going to say?
That's Malad. That's the volatile area. Everybody, Malad.
Third criteria, tailor-made, with the predetermined mind, nepotism, favoritism. That I do not think that because you have been spared, so you have.
But
Everybody has the.
Malad, I think I should not be spared like this. I got it, Malad, interview. It's not that, Malad.
So now the only ground is that they have taken a particular stand, whether that stand is legally sustainable. But not on that ground of third and thirds, nepotism,
Fourth is, Malad.
No.
Fourth is, Malad, this cannot be a reserve vacancy. That then another.
Right. So first, tell us. I think that you should argue the fourth point first.
Well, first your Lordships that I stood first in a vacancy. Now your Lordships.
It can't be a reserve.
Malad, I tell your Lordships, my case was rejected by the authority that I was not meritorious or I stood not first. That I wanted to show. That was the rejection order in the read court.
Forget about it. We will see what the authority said.
Authority said I was not meritorious.
No. Show us that the authority said not meritorious.
On page 148
of
the stay application.
Was
Page 149, longest paragraph, last but one.
So the document has to be read as a whole.
All good. I was going to Malad the finding portion.
Whatever.
দুটোর সময় নাও দেখ বল আর্গু করছে See, my lord, I use this language, pardon me, the tailor-made, this is tailor-made.
Not a tailor-made, that's a.
Any even. Well, they say on merit. At that point of time, also reservation didn't come into Pamela picture when they passed the order pursuant to the order of the court. So someone wants to protect him. Now see your losses. The annexure they have annexed to the authority in the affidavit in opposition. How they get it become reserved. আমাদের roster পেয়েছি মানে 100 point roster 50 point roster. But they have said this 50-point roster rightly for promotion. Page 27. Disclose করিনি। Now your losses will find date of occurrence of the vacancy. My lord, 28th August 2009. Interview, my lord, in the advertisement is 2016, no? 2015 or 16. Just a minute, my lord. 2018. Now, I tell you, lordship, this date, 28th August 2009, is the date of establishment of the institution. So, my lord, first vacancy always go to the scheduled caste, as per your lordship roster. Your lordship is dealing with now. Even 100 point or 50 point. First point always scheduled caste. So, my lord, they have shown Bhaskar Saha. I will show, my lord, after on 28th August 2009, somebody else was appointed who belongs to scheduled caste. So this is not the first vacancy. Your lordship, get my point. Your lordships, I will show to your lordships.
No, I got it. We will take that. Yes.
Then your lordships kindly see the next unreserved, ST, UR. I believe, my lord, 5th is the vacancy now. I will show that document. আমাদের এটা annex করেছি কি? এটা একটু নাও। আচ্ছা।
See, if I say, because of the resignation of Mondor, as people of
My lord, your losses is getting it.
right-hand side remarks.
Right hand side, last one. But your losses, it's a rotation. Obhijit Mondal may be scheduled caste, may not be scheduled caste. But rotation is vacancy may go to scheduled caste, scheduled tribe or unreserved. It depends upon rotation. Now your losses will kindly look at this. I'm giving to your losses. My lord,
First, if you schedule caste, on the chapter, that may be go to the scheduled caste. Point of roster. It does not mean that these are the posts, the point of roster. Point of roster, how
now your losses, 28th August 2009, the date of establishment of the college. Now, my lord, first appointment to the post of assistant professor, Dr. Sujata Vishwas, SC. Kindly see the date of appointment, 3rd December 2009. My lord, remarks by dated such and such. Second, my lord, unreserved, Dr. Sujata Banerjee, appointed on 17th November 2009. Third, unreserved, Dr. Deepa Saha. My lord, this vacancy occurred due to resignation of Dr. Suchandra Banerjee. Then fourth, ST, Dr. Obhijit Mondal. They are not giving you losses the correct picture. He was appointed on 19th March 2014. Vacancy occurred due to resignation Dr. Deepa Saha. Then fifth, unreserved, Bhaskar Saha. As per roster, this is unreserved, 50-point roster. Matlab, this is not the post, this is the vacancy. Is at any best, matlab, he cannot be the first one. One has to consider all the appointments made so far against the post of assistant professor, and then so they have not said how they have maintained the vacancy per roster. The affidavit is not clear. They show the first one as if this is the first vacancy after creation of entire matlab, cadre. Cadre may be single cadre may be consisting of number of posts. Now your lawsuits.
Hmm? Hmm.
এটাই স্যার সেটা তো আগে
Yes, yes. completely right.
This is the, my lord, roster for your losses. Your losses, still your losses knows it. This is the roster. My lord, a 50-point roster according to them which they have followed. There are 2 copies. Now, this is one thing, your losses. One way of looking into it according as my little knowledge I placed it. Now, other thing I am searching is that I was found one thing more that goes to the another root of the matter. UGC says that you have to follow the roster of your respective state or the in respect of SC/ST department wise, not post wise. That means if it in the
You have not made out a case.
well, that's your losses. I do not find anything for the opposition.
If you make out a case of that nature before the
Single bench didn't.
for the first time before the appellate court, you wanted to take something which is factually.
Well, this was not ours. This was not disclosed by them.
I can give you a judgment of the apex court which says you cannot take something you have not taken.
But if
The pure question of law is the different. But if it's a mixed question of fact and law, then there must be an element of pleading.
I tell you, losses. The last point we urged, vacancy roster, this was not also owned to us because it's a general vacancy.
Whatever.
This was a general vacancy.
That is there in the pleading itself, we can go.
That's your lawsuits.
That's all. If
That-
they have disclosed some facts, always,
No, this is point of law in the sense.
not a point because it depends upon certain facts as well. They have to deal with that facts, whether they have considered it in a departmental wise or they have considered as a general post, they have to give a response to that.
Now, the document shows they have proceeded with post-wise. Kindly have a look at this, your losses. I take it. I will not take their
Physiology department, what are you talking about?
physiology department assistant professor.
That's all.
That's therefore your lordship post-wise.
Right,
All right, your lordship, I have not pressed that. But this goes to that. They say proposed twice. So, my lord, therefore, the post to which I, this is also unreserved post. So, this is my lord, all that I'm submitting. Also, ultimately, to protect someone, this is being done.
My lord, that any question of protection is not true, my lord, because he's completing his MD from another university, not a University of West Bengal of Health Sciences.
Answer one. Was an outcast because of your son.
In our reply, we have stated in point C the why we have taken the candidate in spite of that is the reserve category as per the roster point. Now the question of roster point, which one provided by the by learner fed, that is fifth হচ্ছে unreserved Dr. Bhaskar Saha,
What should I take?
the provided by learner.
This one.
This one. Point of roster 5, unreserved Bhaskar Saha, 4/10/2018. The point is unreserved as per the roster. Candidate here is ineligible, less matters. But the resultant vacancy, next column, resultant vacancy as per 2018 advertisement, true vacancy occurred after promotion of Dr. Sujata Biswas on 4/10/2018. We have in place of Sujata Biswas, who is the appointed, the SC category, we have declared the same post and the publication was published, but we are, it is,
Let us understand. Now I have come.
yes, ma'am.
Let us understand. 50-point roster is an admitted position.
My lord,
According to this 50-point roster, the fifth and sixth vacancy must be an unreserved vacancy. You can't deviate therefrom.
my lord.
Let us see whether it is a fifth vacancy or a sixth vacancy. First, take this chart and just giving you please answer that. The institution was established in 2009.
My lord,
No question.
no court.
The first vacancy is the sanction post must go to us SC.
SC.
So,
My lord,
here the Dr. Sujata Biswas
my lord,
was a drug category was a post.
for the post.
Correctly.
Yeah, yes.
Then second and third, those are unreserved, where Dr. Suchandra Banerjee and Deepa Saha both were appointed.
Both are,
If you look at their date of joining, it is a very in a close proximity. One is 4/1/2010,
my lord,
another is 11/10/2010. In a span of say 9 months.
9 months.
So they were holding that post.
My lord,
Now you say that Suchandra Banerjee, she resigned.
no, Sujata Biswas, first one.
Suchandra Banerjee resigned.
Yes, resigned.
My
My
So
lord,
it becomes a fourth vacancy.
good vacancy.
Fourth vacancy is reserved according to 50-point roster.
According to 51 register,
It is reserved,
reserved.
unreserved, but it is reserved. You appointed Abhijit Mondal.
Abhijit Mandal,
He is a reserved category candidate.
reserve category candidate.
No problem.
No problem.
Then, Deepa Saha, who was the second unreserved candidate,
Category.
she resigned
Resigned.
when 2013.
2013.
So then it becomes a resultant fifth vacancy,
Resultant vacancy,
which is under UR.
which is under.
Sujata Biswas, he was talking about fifth, not fifth, actually. Then Sujata Biswas, who was a reserve category candidate, he was promoted.
Promoted.
So it becomes a sixth vacancy.
It becomes the sixth vacancy.
Sixth vacancy is UR.
Unreserved category.
If this is a sixth vacancy, how can you keep it as a reserve vacancy? He was talking about fifth, I am taking it sixth.
My lord,
How it becomes a reserve?
this is, I have again, it is, I am unable to make
Second
you
point.
understand.
If this is on a factual aspect, this is the second point. You never disclose that it is a reserve vacancy.
Yes, my lord, this has happened. Yes, it is not,
I'm telling you, either in the advertisement nor in the decision taken by you pursuant to the order of this court. In the order that has been forwarded, where is that order?
149.
148. Your authority. He never talked about any roster. At 149, the third paragraph, fourth paragraph. Now therefore, have you got that?
Yes, my lord.
After careful consideration of the entire facts and circumstances, it transpires that Ms. Nundi's client, they are selected on merit, on the basis of the interview, where the applicants are given an equal chance to participate. Moreover, two candidates, one is Mr. Sanyal's client and Ms. Nundi's client, were pursuing the MD course for the same academic session, but from the different universities. Then Nundi's client was allowed to apply for the check post. That you can do. There is no difficulty. We are not agreeing with him because we will interpret the NCI guidelines in this regard. At the time of the said interview, the university is honored to make the process of selection democratic, broad-based, and to increase the talent pool means on merit. The same post allowed such and such, otherwise, where you have taken a result, you did not. Now, can an authority change his stand before the court?
No, my lord.
I'm talking about
Yes, my
MS Gill's judgment. I'm just talking about that.
authority cannot change his
I'm
stand.
talking about MS Gill's judgment of the Supreme Court. Can it? Initially, I was with you. I tell you very frankly, because he has not placed that paragraph. But I find there is a reasonable explanation which you gave in paragraph capital E. He was saying about many things, Mr. Sanya, but we were not really content. But after looking all these things, then we find that your stand has to be justified. He was a good explanation. He was saying why he permitted me to participate in the interview if it is a reserved category. Answer is E.
Answer is yes.
Very correctly. Very correctly. But what about this?
In explanation of that, I can say only one thing that university knows that that is the reserve category, but it is not declared.
The 50-point roster does not indicate it should be a reserved category. The schedule is here.
Yes. I hope so.
Fifth and sixth vacancy must be an unreserved. If it is either fifth or a sixth, it should be unreserved. It is only the seventh vacancy which will go to a reserved category.
Really applies that I don't have any explanation about the 51 roster. That only except one thing,
No, you have
that
taken
is
a
the
plea.
Sujata Biswaso SC category. He was promoted.
You have taken a plea that you have maintained a 50-point roster in clause C of your
Yes, my
opposition.
lord.
Yes, said so.
Yes, my
In
lord.
the said notification, application invited for as per 50-point roster.
Yes, my lord. We have
Said so.
says it.
And this is the 50-point roster.
This one,
This says that the fifth
and sixth post
vacancy
is
shall be
unreserved category.
reserved.
But this was occurred
Who
due
is
to the
gentleman who is a firm?
occurred due to the because the SC candidate has been promoted and the post was vacant for the SC candidate. That was been I can
Then why you did not reflect it in your decision? That is a decision communicated by a registrar. You did not. You never talked about any 50-point roster. You never said that the vacancy is reserved vacancy. Nothing you did not say. You simply took a plea of merit. You say that talent must be applauded. Talent
We heard that
should go out.
we heard that in that
Very
case he
clear.
is the more meritorious because we have declared that all the candidates the Orphan Visage is aspirant good. We have in the result sheet we have declared that he is good.
True.
Yes, 100 page number 105. We have
He's the
declared that
best, not good.
good
He's
but
the
best best among the students.
Yes.
So we can't.
He's good, but he's the best.
So in that case we cannot take a plea that on the merit also
That goes against this.
against this. This is the only thing.
Is it not a case of a nepotism and favoritism? You wanted
not
some
so-
candidate to come.
not nepotism, but in decision after the court's order, there should be mentioned that the post was vacancy due to promotion of the SC candidate. Then in that case, it will be
Then follow the 50
Yes,
point
ma'am.
roster. Then the principle would be that if there is a vacancy of a reserved category post, then that vacancy will be filled up by a reserved category. No question of any point roster. That have to have been straight away. That you did not, you have said 50-point roster. Bad. Same thing. Mr. Samanko was arguing much earlier in forest. What has happened there? What is this? The action order was failed. Same thing happened. Very unique case. You know what has happened there?
In Mr.
There
Samanto's
were, Samanto's case, there were 3 regular sanctioned posts of APCCF. 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 There was a blue-eyed boy below that. A I'd say the ex-cadre post was created. 4th one came. He was promoted to as an ex-cadre post. And then out of 4, for the next promotion, this ex-cadre post candidate was pushed to as the highest post, FX post. Making a channel so that he can go. We were very critical. Said no, can't be. It's a case of absolutely case of a nepotism. Sorry, yes, Ms. Nandi, can you throw any light on this?
My lord, one submission is this, my lord. Lordship, kindly have a look to page 56 of the application. My lord, in the read petition, my lord, number 1 is Dr. Jyotirmoy Biswas. Number 2 is Dr. Arpan Kumar Ghosh, the present applicant. My lord, in the read application, they have not made out any case of Dr. Arpan Kumar Ghosh. It was my lord, I'm placing the read application before your lordship, my lord. Only 3 things they have stated. One is this: university cannot grant permission to submit the my lord, documents at the time of interview. Interview has been done on the basis of merit and seniority. And thus he is the junior, my client is junior because he, my lord, joined on 1st of December, my lord, 2009, whereas the, my lord, respondent authority, my lord, here the appellant and, my lord, the writ petitioner, they joined, my lord, 11th of, my lord, 11th of November 2009. My respectful submission is this, my lord, that self-same, against self-same notification, my lord, these three people joined, my lord, in the post of the demonstrator of the said university. But, my lord, no, my lord, case has been, my lord, made out, the writ application, my lord, on behalf of Arpun Kumar Ghosh, who is the appellant before your lordship now. Neither, my lord,
Here in this section, they have used the expression petitioners in plurality.
my lord.
So it is a combined effect. It is not that individually one has to make out.
No, that is true,
They have come and challenges that particular entire process.
my lord.
To say that the petitioners are agreed by that, then you can't say that nothing has been made out for them.
On behalf of Mr. Millot, whatever Millot, yes. Second point is this, Millot, that my client, though Millot belatedly submitted the result of the Millot practical examination.
Now the question has diluted to some other extent.
My lord,
We are at one with you that we have found that the contention of Mr. Sanyal is not correct. That no permission can be granted or he must hold the degree as on that last date of submission. No. Because I tell you very frankly, because he must know. He has given me a medical council of India because advertisement says eligibility criteria as per the rules.
Right.
And the very opening word of Schedule 1 is every appointing authority before making an appointment to a teaching post, making an appointment in a medical shall observe the following norms. Then it says all medical teachers must possess a basic university or equivalent qualification in the one given in the schedule. And the schedule definitely says that the MD or MS for the assistant professor. So it should be at from the date of making an appointment, not at from the date of the.
my lord, my respectful,
Otherwise, in class 12, somebody appeared and then he is also aspiring candidate for a medical examination or the engineering examination or a CLAT, whatever. The result is awaited. The only condition is that no, at the time of an admission, he must pass.
my lord, may I make,
So we are not very much concerned about it.
my lord, may I make one, my lord, one point is this, my lord, that this is not a case of, my lord, fresh appointment. This is a case of, my lord, departmental proportion.
We are at one. Now the question is that what should be the criteria? The merit must be a criteria.
My lord, my client is also obtained, my lord, gold medal at the time of MD examination. Afterwards, I have annexed that in my opposition.
That the marks have been given.
Yes,
Have been awarded a 6.9 marks. No difficulties, madam. If there are various parameters, what is the ultimate thing which the authorities will look? Is the total marks obtained by each of the candidates.
yes, my lord.
It appears that the total marks obtained by him is much higher than you.
Hmm.
It is more meritorious. Somebody may get in one parameter the higher marks. Somebody may get in one parameter the lower marks. That is what is the way of judging the merit. It's simple practice.
And my lord, now the two posts are lying vacant, assistant professor. And my lord, my client is working as assistant professor since October 2018. My lord, it is now near about 6 years. In physiology, my lord.
Other posts are vacant.
Yes, two posts are vacant. That is, my lord, my instruction. And
Yes, my lord.
By her statement or
No. It is and be frank that Mr. Jyotirmoy বিশ্বাস in the at the time of writ petition of that if there is a next post vacant, we will consider them. We tell them that. at the time of writ petition, that in the next vacancy, we must consider your.
Recently, I am
Yes,
told one post has become vacant.
No, two posts are lying vacant. My lord, that is my instruction because, my lord, associate professor, my lord, one post is lying vacant. So, my lord,
Associate
no,
professor,
assistant professor, two
Assistant-
posts are lying vacant.
I am told one post.
When it will begin,
Small.
any one post after this, when it will begin,
My lord, it is vacant, my lord, since, my lord, April 2024. New instruction to
I am
new.
told that one post has become vacant in 2023.
Let him take instruction because my instruction is this, my lord, two posts are lying vacant.
Two post, one post doesn't make any. If the roster follow,
we are more thinking about a social justice than vacancy arrives.
The recent vacancy. But exact date, right now I can't tell you lawsuits on instruction, but I'm told 2023. And that would be, my lord, according to roster, 8 vacancies.
That will be next 7.
Six,
So
seven,
your
seven,
one is-
seven, seven vacancy.
One is 6,
6, 7 vacancy. That will be scheduled caste.
obviously. He's a scheduled class.
That, your lordships, I am not standing. I'm only praying for the date from which he was promoted. I should be treated, promoted with notional benefit, and your lordships can accommodate. That much I can. I'm always accommodated. That much I can, but my protection should be given from that date, notional benefit. But he can be accommodated against seventh vacancy. That your losses can do. On
My lord,
seventh vacancy, the chart I have handed over
We are seeing 7 vacancies.
on 7th December 2023. Last one.
sixth and
Sixth.
But it would be counted from that day.
Milord, my only submission is this, Milord, I am rendering some services since,
Very frankly,
my
till
lord.
this time, we are not convinced with the authority. The only way is, if it is definitely a case of a nepotism and favoritism, we will have to scrap it. And we will direct the promotion to be given. That's for sure. Now, only a social justice. Since you have been there, you should not be demoted. One vacancy has arisen, which is again reserved for scheduled caste. You are a scheduled caste category, so at least you can be saved to that position.
My lord, my lord.
yes, my lord, it is possible.
Let's do this.
My lord.
Make a caustic remarks against it. What about the actual benefit? Since he considered notional, we are not going. Thinking of actual benefit to be given to him also.
Well, we also take instruction and inform.
Come day after tomorrow.
My lord.
Let's just keep it tomorrow.
You are in a very bad shape.
Yes, my lord, but a little bit time, my lord.
Little time.
little bit, but
Let them
because I
realize
have to make
Otherwise,
representation and
they
they
will
will
not-
give
if
information
they
from.
in accordance with law, then what is the law we have to say?
ডেট গুলো জেনে নিন
Well,
কমিটিতে
I-
ভ্যাকেন্সি হয়েছে
Matlab, till 16th, tomorrow I will be here. My learned junior will be here.
Don't you
That-
realize the pulse of a court?
No, I feel them. But personal ground, I will be absent
Oh.
because of my daughter. All right. তুমি থাকবে।
Monday,
My
my
lord.
lord.
ডে আফটার টুমরো করুন হ্যাঁ
Right.
গ্রেটফুল মাই লর্ড
Matter, the state, the statutory authorities are directed to disclose the response to the queries raised in course of the hearing on Friday. This the matter as for orders on Friday.
মাই লর্ড
But through online, I would permit me a losses if necessary. Because I
I have heard you. no
all right, then it's not late.
গ্রেটফুল মাই
সংঘবিচারণ সংঘবিচারণ
Item number 25.
I appear for state respondent.
Noting.
that there is some error committed by the school authority for my last application. Well, they forwarded my general transfer application, but without NOC, which is why when a DI rejected my last application.
Where is the order of rejection?
Well, page number 33. That I am only canvassing that part, nothing. Page number 33. Well, serial number 2. Well, 8. Well, my
33 is your application.
is
Where is the forwarding?
forwarding. Well, extreme right side. Remarks.
Yeah. Is 33.
Is my lord.
No, it's a P4. We do not find any remarks.
P7. P7.
Not page 30.
Yes.
P7.
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 The application.
Stay application.
This is the page 33, sir.
Well, stay application. Well,
For transfer.
yes.
Portal.
You are reading.
The portal status, page 33.
Yes. Total status.
This is the page 33.
Well, I shall.
No, this is the page 33.
No, my lord, this is not my application. This is Monica Mehta.
Someone else's
Sir
file.
Saha. My application
File bhul diyecho. Which matter is called?
25.
25. Sumita Shaha.
It is a
But my lord,
But
CAT
that-
application is different.
Someone else's application has been.
My lord, make it not.
we are really astonished that what you are saying and
Oh, yeah,
what we are
that's-
different. দেখো কোথায় আছে?
Main thing is, my lord, school forwarded my application without NOC. That is why that's
The documents. Where is your application? We
Yes,
have to
yes, yes.
find out. File, here,
is
application is filed here.
Can.
no can my lord, stay application. Can.
The presentation form, you have to see in which court it will be listed. Right?
Yes, here, my lords.
This is what I say.
Yes, yes.
You file here.
Here, my lords.
That is okay. Service file.
চলো আপনি
Picho.
না তো এটা কি এটা দিয়েছে
আবার জানি না চিন্ময়
তোমাকে কি
চিন্ময়
তুমি কি করছো
কপি এখানে লিখছি আপনার নাম
আমার
এই সার্ভিস
ঠিক আছে আপনি করে নেন
এই সার্ভিস করিস নি কার উপর সার্ভিস করছিস?
এটা তো আমাকে দিয়েছে সুমিত কুমার।
এভাবে মামলা করিস না, আমাদের নিজেদের মধ্যে প্রবলেম হচ্ছে। কার উপর সার্ভিস করেছিস? আমার ক্লার্ক, আমার ক্লার্ক নাই, কোথায় দেখ।
সার্ভিসে দেওয়া আছে।
He show us the affidavit of service.
I have given.
তাও একটা কপি দিয়ে দাও, দেখো।
না না, এখানে আমাকে অ্যাড্রেস করা আছে। আমারটা পরেরটা।
It's only to a government leader.
No, my lord, first page is, my lord, SSC is also there. My lord. is, my lord.
Government leader.
No, not government. This is a school service commission. I have also served. Kindly
Where?
take, my lord, that.
Please don't put there.
দেখে নাও।
No, no, you show us.
তুমি দাও, তুমি দেখো।
এই যে
Please
ঠিক আছে,
address
চিন্ময়
also
রেখে
the leader.
my lord, it has been addressed, but my lord, it has been received by the by line.
My lord, my learned senior friend is appearing for full service commission.
But he's raising an issue that.
No, my lord,
My lord, though my lord,
Yes,
served,
right.
it was served upon my clerk.
So you are appearing for.
My lord, I am also appearing, I am also an impaneled advocate of the school service commission, my lord. But in this matter, my lord, Mr. Dr. Patra.
Let my junior friend do it because
No.
he is also competent.
No, no.
But I am only annoyed because without service, creating a confusion between the empaneled lawyers, that is not fair. We
My
all
lord,
have a
it
very
has-
good
it has-
relationship amongst ourselves, but now we are becoming
Probably-
enemies, if I may use the term.
That he's appearing, why you did not immediately contacted him?
My lord,
But it was, he received it as you are a government, you are in a
SSC.
government panel.
no, commission, school service commission, my lord.
It was addressed not to you, it was.
Yes, my
addressed
lord,
to a
it
government leader.
Yes,
My lord,
I'm
it was
appearing for the
addressed
state.
to me also, my lord. Wrongly, probably wrongly, it was served upon me.
Endorsement there is, I have served properly, but the mistake committed by my clerk. Probably I have directed to serve Mr. Patro, Dr. Patro, because he is the learned advocate before the trial court. By clerk wrongly, probably it has been served to Mr. Ray, who is also an impaneled. That is the main difficulty. My lord, I have served. There is no doubt, undoubtedly served. Without service, my lord, I shall not present.
Application,
Then
pass over,
let it be passed.
give him a copy.
I shall serve Mr.
My lord, I am handing over my copy to Dr. Patra.
Directly upon the client, on the commission, and then we
Also, also.
decide. And that is the procedure. We do not want to fight amongst ourselves. Such a wonderful relationship we have in the profession, why should it be disturbed?
So, Mr. Dr. Patro, one thing which really struck me since long. If you have appeared before the single bench,
Yes.
then it is better that you should appear before the division bench.
But this is the,
It should be the same counsel who should appear before the division bench as well. Hey, bosso.
Is that,
Right.
that is why when I saw item
So
25,
that's why it's better that instead of sending the client, it is sent to you that I have preferred an appeal.
that is also a practice. Sometimes we send it.
my lord, that is the,
As far as appeal is concerned.
Yes,
not
yes, that
as far as
is
the writ,
done.
It should go to the client.
Yes.
Well,
Well,
even Dr. Patro always asked me that if I was appeared in the single bench, hand over to appeal copy to me. Well, my clerk committed the mistake even before pressing this application. I SMS Dr. Patro that if the matter is coming, please come. So, my lord, I have no knowledge that copy has communicated to the Mr. Ray. That is, my lord, I am tendering my apology. I have এটা কপিটা দিয়ে দাও
আমি দিয়ে দিয়েছি।
না, না, ঠিক আছে।
Find out. Techo,
এই যে দাঁড়াও,
এই দেখুন।
my lord, page 33, my lord, only application forwarded
Not-
without
not any very bad English, not having a proper NOC.
NOC. So my lord, only prayer, if the NOC is given, DI applied his mind and consider my application. Since there is an defect in the processing application,
Who is for the school authority?
My lord, I appear for the DI, state.
Wait.
School authority, with a party. To serve the school.
the DI refused, my lord, DI.
No,
Lord,
before DI.
I shall.
Unless the NOC
I
is
shall.
there,
Yes.
then how can he process?
Exactly.
I shall.
This that cannot be faulted
No, not faulty, but only, only my lord,
to serve the school,
Lordship.
otherwise we will.
Lordship,
5 and 7.
lordship.
Service
I
is not complete. Let
Lordship.
this matter be listed after 2 weeks.
Lordship.
Let the service and come back.
Lordship. তিনজনের নাম কি আছে?
No.
26. 26 নাম কি গো?
Anybody is appearing?
Not arm for the state.
Not for the board. Anybody is appearing or not? These of the headmaster of the school.
Terminated man. Terminated long back man.
In 2004 and 2006, he job was struck. My lord, my case is that the allegation is made as I have produced the false caste certificate, which is not. Later in the RTA application, it is found that I am belongs to the scheduled tribe categories. Scheduled tribe categories, and it was well established. Well, in that.
সবগুলো নিয়ে না এখানে রাখো, ওদেরকে দাও স্লিপ দিও। পেজ কত?
26.
তুমি না বুঝতে পারলে আমাদের দাও। তুমি না বুঝতে পারলে আমাদের দাও। ক্যান্সেল করে দিয়েছো? বুঝতে পারলে
Order
না, বুঝতে পারো আমাদের।
Well, the order of the land is land is single judgment, which was annexed with the appeal. But it was directed that
where is the order rejecting the cards?
ওই দিকে মায়ের না করে থাকে।
my termination matter.
You are challenging a order passed in a cancellation proceeding.
Yes, my lord, I have challenged that the
Oh, my lord.
termination was made, which was
ওইটা আমাদের
really the seventh termination.
Where is the order?
My lord, in the CAN application, CAN 1, I am stating my lord.
Change. What is the order?
My lord, page 33 and 34. I have been
না না এটা কত কথা কেন কিচ্ছু না সব
3 and 34,
কোনটা
the CAN application 1. CAN 1.
এটা এখানে তো কিছুই বলে যাচ্ছে না রাইট
This is a personality test.
Page 35 issued by the managing committee man.
My lord, decision of the management.
Solve for that. Page 33 35 এটা
Yes, my lord, 34.
5/4/2006 was decision of the secretary.
My lord.
What you were doing from 2006?
Well, and I made several representations,
Then
well, several.
One representation of 2006, 7, 8.
My lord.
One representation for 2006, 7, 8.
Actually, my lord, I first applied for the whether my certificate is a caste.
I'm asking you very simple questions.
It was not annexed with this, my lord.
So there was nothing. Only in 2022, for the first time under RTI, you asked anything, and then you started the entire process.
My lord, since RTI given me that I am the genuine caste holder, so that's why I came before my lords. In that case, my lord, I
There
want.
was a proceeding which was initiated. You participated in the proceedings, and ultimately it was cancelled.
Yes, madam. In
Madam, I
2000,
want-
2000,
Challenge that order.
2004, his caste certificate was cancelled.
Because certain caste may be subsequently included by way of an amendment.
No, my lord, this is not. Kindly see, my lord, can to page 11. What has happened?
Order is staying at your place, cancellation order. Why you did not challenge it?
That time, my lord, the question is whether I have a caste certificate or. My lord, there is an erroneous made by the department. Why I am showing, my lord, kindly see can to page 11. Can to page 11. Can to page 11. From the second part. Can to page 11, the applications from the learned council to page 11 is the prayer portion. My lord, can to. This was where I pay for the section 5 applications, my lord.
Section 5, forget about it. I am talking about the merit.
In that case, this is where the letter was given, which is very much related to this. So that's why I'm praying before your lordship.
This is the letter given by you in 2024.
And to the state public relation officer, can you go through the second paragraph, my lord? It will clear the picture, my lord. Second paragraph. The two caste certificate for Miss Peter's representation made. One of some
2004, not
Noria, my lord, that was linked with my case and I have been terminated. This is the,
April
Has to be.
because I am schedule type and she is OBC. I do not know, my lord, that why this mispresentation made and I have been terminated.
Still claim it's got to be. Resuscitated after several decades. Now, after more than a decade, by approaching the rich court, challenging the order of termination dated 25/4/2006. The petitioner was given appointment as assistant teacher, primary school,
No, my lord, secondary
the secondary school,
2004.
as reserve caste, as a reserve category candidate, and worked for nearly 2 years. Subsequently, the serious allegation was made over the caste certificate submitted by the appellant, and a proceeding was initiated by an appropriate authority, being the cancellation proceeding case number 13 of 2004. The subdivisional officer found that the caste certificate issued by the department is improper and cancelled the same by an order dated November 8, 2004. There was no challenge to the said order as the appellant remained silent. Obviously, for the reason that he was still working as an assistant teacher.
But at that time I was terminated.
No, more order was not. Subsequently, the said order was brought to the notice of the managing committee of the said school, and by the impugned order dated 25, what is this?
It's 35, madam.
By an impugned order dated
April 25.
and 25/4/2006, the service of the appellant was terminated. Even thereafter, the petitioner did not raise any objection nor challenge the said order of termination. And it is only in 2022 an application under Right to Information Act was filed seeking information on the queries probing, and after receiving the reply, the deduce would is sought to be given a fresh life by approaching the writ courts. Astonishingly, apart from an order for setting aside the order of termination, the petitioner has claimed the salary for all such period for which he admittedly did not discharge duties. The order of termination is still staring at the face of the appellant. And such order cannot be interfered after such a enormous lapse of time. Though there is no period of limitation provided under the Limitation Act for taking out an application under Article 226 of the Constitution of India, but it has been but a constant views have been taken by the courts that the delay and latches can be a factor to deny the relief unless the case comes within the purview of the violation of the fundamental rights. The petitioner got the job on the basis of a certificate under the reserve category, and the said certificate was subsequently cancelled, and the order is and the said order has been interfered with. The consequent step taken by the school authority in terminating the service of the petitioner on the basis thereof cannot be faulted with at all. Cannot be faulted. The moment the foundation of appointment is found to be illegal, the castle built thereupon cannot stand and has to fall as a consequential effect. We thus do not find any merit in the appeal.
But the mistake made by the subdivision officer giving me different caste certificate, my lord. Though I am a scheduled type, he is given me OBC. That was found later. And he has rectified, madam.
What can be done, sir? What you were doing for so long?
Twenty.
27 for that. This is my service minute.
Just tell me.
So that
I'm for the school service commission.
there is they have not taken any steps. on
No,
this application.
only my last application is pending before the School Service Commission on spouse medical ground after two-tier filtration. Not
That was
Has it, you either rejected that.
yes,
is
that is only my page 30.
decided.
Page 30.
Simply because he made an application under general transfer, this cannot be. And this is a gynecological disorder.
After two-tier filtration, it has been posted to the SSC, which is pending for a considerable
Pending before whom?
commission
school service
for
commission.
the recommending. of-
So
Already, as
If
per
your lordship so directs,
they have to consider.
the petition filed by the appellant alleging inaction on the part of the School Service Commission in not taking a conscious decision on an application for transfer under on medical grounds is rejected by the single bench as the earlier application for transfer filed by the petitioner on other ground having rejected, the subsequent application is not bona fide. There is no barrier on the part of an employee to apply for transfer if the circumstances necessitating such transfer is different. The different. Though the learned single judge has opined that the rejection of the petition shall not prevent the petitioner to make an application seeking transfer if the situation arises in future, the second application necessitated by a medical emergency should be considered as a change circumstances. And therefore, the rejection in such manner does not appear to be appropriate. Furthermore, the application filed by the application for transfer on medical ground was processed at 2-tier of the system and has reached to the domain of the School Service Commission. Such, full stop. Such facts should be taken into account as the authorities at the foundation level is that the grounds for raise needs to be scrutinized by the higher authorities. In such view of the matter, the order impugned is set aside. The School Service Commission is directed to take a conscious decision on the said application. Within 3 weeks from the date of the communication of this order.
Great.
In accordance.
Great.
All right.
Huh?
All right.
How do you expect that at this age health will be all right? But mentally I'm all right. I'm all right.
Has to be
What?
the way you cough.
Huh?
The way you cough.
Ah,
I just thought
ah,
that everything is all right.
I think so. Everything's all right. There is some inherent problem, but anyway, still I'm fighting. I'm all right. And just say Dipangar Gupta repeatedly warned me, don't do that, don't do that. What is that? There's a bit of service, my lord. There's a delay of 30 days, my lord.
30 days.
26 days, sorry, 26 days.
Let us see what our stamp reporter has said.
Yes, 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 that must be.
It does not.
Huh?
It does not say that there is a delay.
No, how many days?
0 days delay.
0. No delay.
That's stamp reporter.
My lord?
This is a stamp reporter's
No,
report.
when you have seen that.
Let me calculate.
As I'm told, my lord, I didn't look into this. Normally, you always depend on the stamp reporter.
What is the date of the order?
Date of the order.
3/5.
দেখেছো এখানে জল খেয়ে দেখেছো
3/5. 3rd April. Yes, 3rd May. Has to be delayed. 3rd May. Because your application is on 10th of June. How he can say that there is no delay? A stamp reporter ke डाको तो.
Let me verify, my lord. I'm waiting, no problem. Call the next
No,
matter.
no, no, not waiting. What is the matter about?
Matters is the order of the day, my lord. These primary teachers and these servants, all these things. We are the successful candidate.
You are?
Successful candidate. And at least up to this date, neither CBI nor any other authority just found any allegation against us, any wrong, so what we are concerned. 2014, 2016, there were at the time of publication of this panel, the authority says, if you really want to see the OMR seat, please apply within 30 days. We'll arrange it. No problem. I'll give it. Some of them not here. They applied, they got it. These persons, my lord, 5,500 applied, they got it. But these persons, my lord, after 2 years, woke up on the slumber. The unsuccessful candidate. So my lord knows, my lord, first thing, unsuccessful candidate. That is initially there was first judgment delivered by the Supreme Court in the tender case. Unsuccessful candidate, he cannot challenge. Suppose if it goes in their favor, this everything is all right.
Where are 2 orders? Why 2 orders are challenged?
My lord,
But on this,
in this matter, my lord, Mr. Bikash.
Let us wait. 3rd May order, I am getting it. Where is that?
করেছিস ওইটা থেকে কি কাউন্ট লিমিটেশন পরেরটা লিমিটেশন হবে কি করে যার সাথে তো ঠিকই ধরেছে
30th April. There are 2. Now, first question is whether 2 orders, independent orders, can be challenged in one appeal.
My lord, if the stamp duty is paid, my lord,
I'm asking you this.
if the stamp duty is paid, my lord, substitute losses correction probably can be challenged.
One composite appeal against the 2 independent orders.
My lord,
One composite appeal
yes.
against the 2 independent orders.
My lord, that has been done, but stamp duty.
Tell me.
দিয়েছিস?
No,
No.
don't worry. He has not paid. I am sure. Looking at
দুটো স্ট্যাম্প ডিউটি দিয়েছিস?
120. 240.
Paid or not paid? Not paid.
240 only paid.
Then
What is the stamp duty for one appeal?
কত রান? কত?
400. 400.
400.
তাহলে তুই অনেক কম দিয়েছিস।
দিয়েছে কিভাবে? 20, 20, 20, 20, 1, 2, 3.
Oh, that has been assessed by the stamp reporter. The stamp reporter assessed it,
12, 13, 14.
as I'm told by my junior friend. I'm sorry.
20, 400.
Stamp reporter.
400 is given.
I see. Then it's all right. Then it's all right. Because there is assessed.
800.
Yes, another 400. Because stamp reporter normally report that this is the stamp, and after assessing, this stamp to be paid. So another 400 to be paid.
But now whether the payment of the court fee will cure the
Delay. Delay.
delay is the court, whether it can cure the appeal.
But
First question is whether two independent orders can be challenged in one appeal.
my lord,
We are doing it for the purpose of court fee. We are conscious of
yes,
61 Supreme Court.
yes.
That is, court fee is a matter between a plaintiff and the court. Defendant has no right. But still I am asking.
No, certainly court can ask these questions, my lord. There's no doubt about it. So, my lord, it is a technical aspect,
Technical, too technical.
too technical. But if the money stamp is paid, I appreciate, my lord. If there is two order and challenge is thrown against the two orders, so two stamp duty must be paid. There's no doubt about it. Must be doubted. So one is paid, one is not paid. So unless this money is paid, I must file the compensation. It can't be said that is appeal is in order. In order, appeal is in order. So with the leave of the court, we can deposit that stamp duty.
What the court has done.
Trial court at the first instance. But the point, initial stage, we wanted that point of maintainability should be taken up first. Because after Supreme Court, it is already decided, my lord, because you need not crack the cell and open everything. If it is found that he cannot enter into the room, you don't allow him to enter the room unless he can satisfy the court that it is otherwise maintainable. We say it is not maintainable. Whether it is at all maintainable or not, that is yet to be decided. Very well. But when the point is taken of maintainability, as my lord knows, Supreme Court also, I've also brought some, that that should be taken up first. After, yes. So, my lord, here, my lord, we trial court, my lord, they took that plea. My clients, that maintainability is there. Because the unsuccessful candidate, after 2 years, without applying for OMR seat within the time, after 5 years, not 2 years, 5 years, they came before the score and knocking the door of temple of justice, whether really entitled to have the justice or not.
Now, simply says they don't consider it as a temple of justice.
Oh, I see. But unfortunately, my lord,
We are not a DT.
look, I can tell you one thing. Yes, I've heard it. Yes, yes, no, but I can tell you.
We are definitely a Sevada, the people of the country.
I can tell you. No, kindly, there is basic and fundamental difference. Look, yes, a judge may say, look, I am not the God. You are called. I am not the God. There's doubt about it.
There, globally.
Yes, yes, yes.
Oh, acha. I think one of the best judge
Yes, yes, my lord, we are
order is. This absolutely there is another order. 5th July, there is an order of direction, interim order.
স্যার 5th জুলাই তো চ্যালেঞ্জ করেননি আপনারা?
sir, 5th July কিন্তু
চ্যালেঞ্জ আপনারা কি অ্যাপিল করেছেন 5th জুলাই এগেইনস্টে? ঠিক ঠিক ঠিক। ঠিক আছে ঠিক আছে ঠিক আছে ঠিক আছে।
না না হ্যাঁ এই তো অর্ডার আছে।
Your name has been deleted. Why?
my lord, it was wrongly my lord name my lord in the petition.
কোন পদটা এটা
Mr. Banerjee, only the let us go with the civil concept. The pleadings are filed. The courts after that wanted to frame an issue. The court framed an issue. Is it a case decided to be challenged before the higher forum? Here, simply the court has really framed an issue. You wanted that the maintainability is also required to be seen. No difficulty. The maintainability would be considered. That's the very root of the matter. No difficulty.
Let me reply, my lord.
Yes.
I could have understood when at the first sitting of the court, the case was open. If the plea is taken, my lord, kindly don't open the merit and other things. Do not pass any order. Before that, kindly hear the question of maintainability.
Yes.
মানে on 2nd July
So just a minute. Without doing so,
I will go because he belongs to a civil sister. So do I. So my brother.
Yes.
So we will take care of in that perspective. Don't worry. And one common thread is that our grooming is under the one umbrella. So let us see.
So, my lord, what I am on, my lord, as it is for process, however prejudicial affected. What I am on, before passing any order, first you decide whether at all his writ petition can be entertained or not. That's the first thing.
Now, first, see, in case of a civil suit,
Yes.
if the maintainability is taken as a ground, then Order 7, Rule 11, there are parameters which are given.
Right.
Even for the purpose of Order 7, Rule 11D, barred by law, the court has to look into the pleadings and then think that whether it is really barred by law. So, pleadings have to be gone into.
There's no doubt about it. I'm grateful.
Secondly, if it is a plea of maintainability, then under Order 14, Rule 2,
It
the
should be
court
framed.
has to frame an issue.
It should be framed.
And one of the issue would be the maintainability.
And
the
that's to
court-
be hard fast.
And the court, while deciding all the issues, if found that the maintainability issue, which is a mixed question of fact and law, is decided against the plaintiff, then he is not supposed to answer the other issues. But there the pleadings are also required. Issues are also to be framed apart from the issue of maintainability. There are one aspect, distinction. One is maintainability, issue of maintainability purely on the basis of a law, and an issue of maintainability based upon facts and law.
Next question of action.
If it is a mixed question of fact and law, then every issues have to be framed, and at the time of delivering the judgment, he has to decide.
Now, my lord, let me answer my lord, in short way, my lord, as it is rightly proper.
What has been
I'm
done?
coming. I'm
We
coming.
will simply say, since the point of maintainability is also raised, we expect that if such point is taken, the learned judge will definitely take note of
My
it.
lord, let me answer, my lord. Whatever order to pass, let me answer.
But there is
Question
nothing
of
that
my lord,
will
kindly see, my lord. One
decide.
thing is
Point in order.
no, one thing is very clear. As it is found for losses, my lord. Let me answer. What I say, my lord, as it is highly found losses. Suppose X file a suit against Y for a declaration that I am the real owner, he is my penamder. Then reinstatement file, then defendant file an applications that well it is
Not by law.
or that is
No,
totally.
that is
I'm coming. I'm
not
coming.
the-
I'm coming. Coming.
I gave you two examples.
I'm coming. I'm coming. I'm just giving. That's why I'm giving the example. There is one thing. Other is my lord. Even in that case, court must look into the pleadings. Otherwise, in air, nothing can be decided. But as we know, my lord, there is a basic and fundamental difference between the writ and the suit. But here, issue normally not framed. Writ. Issue not framed. For the convenience of the court, sometimes they say, I'll decide on this point. But in suit,
I'm conscious in
I-
a writ proceeding. I'm conscious.
yes, of
But
course.
again, I'm saying that's why, since you have a civil background, so that's why I gave a simple example of this. In a writ proceedings, there is no procedural law
No.
which applies. In our rules, which is framed by the full court of the High Court, it says that the provisions of the
That-
Code of Procedure shall apply mutatis and mutandis. It does not say everything will apply.
No.
It's the principle akin to the Code of Procedure
That's
will
true,
apply.
my lord.
It's a procedural law. Now, the procedure is always susceptible to be adopted by a court while proceeding to decide a particular case. The learned judge has decided that I should frame certain points. I should indicate that this is what the points which really troubles me, which I feel is involved. The basic tenet of this is a more transparency and the fairness, because it will augment the lawyers to understand that these are
What
the
is going in the
points
mind of
I
the
have
judge.
to address and
Yes.
not taken on surprise.
Yes, that's true.
Suppose something comes out of the box.
No, I appreciate.
And
I'm not
then
blaming.
says, I am not
No.
aware of this.
I'm
This is
not-
what is a
I'm not-
good transparent manner of doing it.
I'm not blaming for a
Making you
moment.
aware that this is the points you have to argue. This is not a
Question is this. I'm not blaming. Question is this, my lord. Even before framing the issues, when a point is raised regarding maintainability, only writ petitions, like Order 7 Rule 11. Now there, from the writ petition is appear, admittedly after 5 years they move. And the same, let me finish.
then it
One
is
minute.
a mixed question of fact and law.
No,
First thing is,
one
why
minute.
I say, why Order 7
Let
Rule
me
11 will
finish,
not
my
apply?
lord. Let me finish.
Because let me argue against you. Why it will not apply? First
You are-
thing is, there
Other
is no
side.
law. Limitation Act does not apply to a writ proceedings. Nobody can say it applies. not a single article in the Limitation Act you can find that there is a limitation given for moving the writ petition before the High Court. No. There has been a judicial pronouncements in this regard that says that a person who they sat over his right for a considerable period of time and suddenly approached the court, then the court may refuse to exercise discretion. It's a discretion which the court shall refuse and will not grant him a relief. In order to ascertain whether there has been a delay or laches, one has to look into the pleadings, whether there has been a proper explanation given, whether something has been given. One judgment of the Supreme Court says, only solitary judgment, that if the approach is made beyond the period of limitation provided for filing a suit challenging such action, then there must be an explanation provided therein. But there is no period of limitation. You can't say a bar of law. You can't say a bar of law. It's really a mixed question of fact and law, like Order 14, Rule 2. Then other issues have been framed.
Let me say something.
He may decide the point of maintainability in your favor, will not go into
No,
this.
let me very well. I follow what is followed from losses, my lord. Let me say something. But there are two aspects. Apart from this delay, the issue of the lease which is to be raised, and the writ petitioner, by moving the writ petitions, is trying to raise. If it is already decided after Supreme Court, then what will be the positions? It's not a question of res judicata. Party may be different. Question is this. Admittedly, the issue what he want to raise before this court, some of them, here also some of them also moved earlier, writ petitions. Matter went up to the Supreme Court. Supreme Court decided it finally. How that can be reopened? Court may reject the point.
True. So
Court may reject.
If you these are again a question of fact and the law, both.
It is not a question. It is purely question of law.
No.
Because Supreme Court has decided that it is a judicial pronouncement. Itself is a law. Law is framed two ways. A law laid down by the your lordship. Law framed by the legislature.
And by
the judicial pronouncement also is a law. So if I can satisfy just by reading that, praising the judgment of Supreme Court,
we are making that if you take a plea of maintainability, the learned judge will definitely.
My lord, on
take care of
2nd
that.
July, my lord, there is a specific direction by the
that
Honorable
was-
Single
that
Judge
was taken.
that the issue of maintainability
was
shall be
taken.
heard first.
Where
There is a
is that?
direction on 2nd July.
I'm just website is
Then-
not working. My
no, but show that.
yes.
Why should I?
Soft copy I can show to you.
No.
Give it. No difficulty.
The
Specific direction was there.
After that, how the court will taking time?
On 2nd
Court will
July.
take time to pass on this order. Without deciding that,
That
why
the
is
issue of
taking so much
maintainability shall.
matter.
Yes.
In this
Writ
matter,
petition.
Shantanu Shitman.
Issue of maintainability of the writ petition shall be heard first.
Yes.
So it is there. Issue of maintainability shall be heard first.
Yes,
And another.
after that.
After that,
And another direction on dated, my lord, on 3rd May 2024, that the parties may address on
Kindly
court
see the
on
second
the
slide,
other
first
issues
question.
also. There is a liberty was given to the
On that
parties.
basis,
I'm
the
looking
applicants
at a
have filed
2nd
their
July order.
Kindly come to
Yes.
paragraph 2 and 3. After that, how the court can proceed?
What? After that,
2 and 3.
I'm talking about the paragraph 5.
No. Kindly see
Read
the
paragraph 5.
Kindly see the 2 and 3. 2 and 3. I don't understand. Having heard the learned counsel for the parties, the court directed the CBI to apprise it as to whether the original server hard disks where the original OMRCs were scanned and stored in
আরে nothing fully, এটা তো
or
investigation,
have been fixed
part of the investigation. কখনো
It
কোনো findings ই নেই।
it is submitted that the said original OMRC of all candidates who sat and took the 24 voting were duly scanned.
Mr. Banerjee, all these, Mr. Banerjee, all these directions or all these documents will go in vain the moment the court decides paragraph 5.
Right.
If the court says not maintainable, this would merely a piece of paper, nothing more than that.
Yes.
I say like this. It will
Why you
not
are
act.
apprehensive?
No, I said this thing. if the judge, the concerned judge knows whatever I'll decide is useless, because if there is found ultimately it is unmaintainable, or it will go to the top. So that's why my Lord Supreme Court says, no, first you decide the maintainability.
That
Don't
is
take,
what the learned judge has also said, I will decide the point of maintainability.
but before that order is passed,
That
before deciding the maintainability, how the judge can pass an order? I may be wrong, kindly have a look. 4 and 2 and
Findings
3 is a specific direction. So before pass, if he is entering into the merit,
That's
the
not
learned court will
before
enter
us.
into the
It's not a
merit.
subject matter of challenge now, 2nd July order. It's not before us. Anyhow, here
Anyway, I'm not disputing. I'm not disputing. Rather, it is
do
helping
not
me.
find anything.
That is helping me. The 5 is contrary to 2 and 3. I could have understood. Only 5 is there. All right. But before passing by this order, again, 2 and 3 kindly read it. So if you know that well, everything will be useless. If it's ultimately found, it's not maintainable. Why you pass that order?
Then I give you, again, civil matter, I give you an example.
I don't mind. I'm really, I'll be, it's
Suppose
a pleasure to hear.
Suppose in a suit for eviction of a tenant,
Yes.
the plaintiff on the ground of reasonable requirement. The tenant has taken a plea that, look, the same ground was taken in an earlier round of litigation, and that suit was ultimately dismissed.
No, reasonable requirement may vary.
I am
Today
telling
there is no reasonable requirement.
Sir,
Tomorrow
sir,
may
sir.
change.
Sir, maintainability issue has been raised.
Yes.
Maintainability issue is framed. Landlord file an application for commission. Reasonable requirement. If this principle is accepted, then it will be a futile exercise, because let the court decide the issue first, whether it is a barred by res judicata or not. Let it be decided. What is the necessity of commission work and everything to be done?
Here is the same thing, 2 and 3. 2 and 3, kindly see the 2 and 3.
That is not the law. The
2
law
and 3,
is
my lord.
everything will go. It will be decided.
No,
at
no,
the time.
2 and 3 is contrary to 5. So I could have understood. Court restricted himself. So far the 5 is concerned. Court proceeded further. And before observing that, mentally point to be decided, he passed an order which is contrary to that.
The nuance is that the maintainability point to be taken up first. Learned judge has accepted it.
But question is, before that
I
order
don't
is
think
passed,
so that-
before that order is passed, whether that cannot be done. Supreme Court says, kindly see one judgment.
It's not a case like Alice in the Wonderland.
Kindly see, my lord. Down.
Where the
You cannot
king
check
said
for
that
now.
we hit him first, thereafter the trial will commence.
And my lord, kindly say, I could have understood at the cost of repetitions. Is it rightly fallen from your lordships? And it might be raised by friends that, well, my lord, that is there. Generally, if that is not there, then why the court took trouble to pass the order? So what paragraph 2 and 3 is concerned? Court certainly should not. It will be futile ultimately, because third party is directed. I could have understood is restricted to between the parties. CBI is directed. That means another outsider. He has been brought and he has been directed. How could you pass such an order at this stage before deciding the maintainability? The my lord, one judgment, my lord. I do not know what is the reaction of your lordships, but still, copy
That will be reflected in the order.
I know. That's the last thing. That's the last thing. No problem. Minor से भागने वाला भी नहीं है. And I'm quite old, my lord. Now I know I've lost this case. See, I've lost this case. What am I to do? अरे भाई क्या हो? So this is not
That judgment.
paragraph 9 and 10.
স্যার একটু সাইটেশনটা বলবেন স্যার সাইটেশনটা একটু বলবেন
একটু দাঁড়ান।
9 follow 1 SCC page 193.
2009 1
Paragraph 9, 10, 1.
SCC page 193 paragraph 19 SCC 193 এই তো 91 SCC 193
Of course, there is order 47. Certain order is passed. I want to but how is it? How the court direct a third party that 12 proceed? Paragraph 9 and 10. How the court pass such an order? First, you decide the maintainability. And it's an agency, he will be involved, he'll proceed. And his proceeding, he started the inquiry. The High Court shall decide the question of relating to the maintainability of the review petition and then proceed to deal with it. It is found that the review petition is maintainable. I may lose this case. And subsequent, I'm sorry. And subsequent order more serious. Foreign agencies should take part of it. My surprise, on 5th July, subsequent order, foreign agency is directed to take cognizance of this and proceed. What remains? So he is proceeding. I am not blaming anybody. Question is this on Supreme Court. In all cases says, first you decide the maintainability. Then question of others. One of the order is passed. First CBI, then foreign agency. They are trying to inquire. What remains? Virtually is deciding, started deciding that issue. So that's why I say, my lord, maintainability point should be taken up first. And that court has committed a, with all respect, because I like that court, I like that judge, is very spirited judge. And the system which has followed is to introduce, very nice. So that as it is rightly followed, just stand on. So it's not surprise. What I heard playing in my mind, I'm noting down. Please, sir, please take it. That's a very nice thing. I can appreciate. The question is this: we are all human beings. The intention may be good, but law is something else, my lord. The law says something to be done in some manner. Even the honorable judge cannot be deviate from that. It should be done in same manner. Because law doesn't mean to be mere theoretical abstraction. It's an instrument to do the justice, my lord. So justice should not be fulfilled unless the proper procedure is being followed properly. Maintainability counted without hearing this. He's passing one after other order. How is it? And very serious order. It's actually on merit. A foreign agency has been also directed.
No.
5th July order. Kali call for the 5th July order.
Foreign agency.
কি দেখছি যারা সিরিয়াল দিয়ে খিচুড়ি করছে Fifth July order, sorry. But 5th July order is much more serious. We have not yet received. That is to be taken care of because that is court proceeded further, touching the merit and apart from the maintainability. How's it? If it is ultimately found, why court is taking so much trouble, my lord?
Reply what you received.
My lord?
Reply what you received in your first appearance.
ওটা আর বলতে হবে না আপনি যখন সুপ্রিম কোর্টে জাজ হয়ে চিফ জাস্টিস হবেন আমি তখন বেঁচে থাকবো না nobody knows what will happen. Even Raghunath Mishra never thought he'll be the chief justice of India. চলো আর কিছু করার নেই
He ordered it at 30th April 2024 and 3rd May 2024.
Direction of maintainability point is shown. So my lord is passing the direction that maintainability point should be heard first.
Already the direction was there.
No. This is if that is so, why court is proceeding? I could have understood that where maintainability is taken up. Before disposing the materiality point, he's positioning one after another or passing one of the order. I was a child at that time, and for my consolations, and I'm an old also. So my lord, I can appreciate.
Commonly said that the old is a reincarnation of a child.
সে এখন তো আপনি দাদু হয়েছেন তাই বলছেন। ঠিক আছে তো? ঠিক বলেছি তো রে? দাদু তখন নাতি হয়ে যায়। আর কেন নাতিকে ভালোবাসে জানিস? ওই বাচ্চাটার মধ্যে নিজেকে খোঁজার চেষ্টা করে। Am I correct? So material point should be at first now, before passing any order.
Otherwise, they will not
আরে
understand.
এখনো এক জলও
Yes.
খাইনি, খাবারও খাইনি।
Yes.
জলটা তো খাইয়ে। My lord? ওই তো my lord মাথা নেড়েছেন। May I leave, my lord?
Are assailed in the instant appeal on the premise that the court of first instance ought not to have ventured to decide the issues on merit. The moment the issue of maintainability of the writ petition was raised at the threshold of the hearing, according to Mr. Banerjee, the senior advocate appearing for the appellant, both the aforesaid orders are the reflection of a pre-notioned mind. And in fact, the issue relating to maintainability of the writ petition has been pushed at the back. In support of it to buttress the aforesaid submission, the reliance is placed upon a judgment of the apex court in case of Director General of Police, Central Reserve Police Force, New Delhi, and others versus P.M. Ramalingam, reported in 2009, Volume 1, SCC, page 193. Mr. Mukherjee strenuously argued that it would be a futile exercise. Yes, it's Mr. Banerjee. It would be a futile exercise if the journey is embarked upon the issues or the questions framed in the impugned order. In the event the court found the maintainability of the writ petition in favor of his client. No, I found that the issue relating to the maintainability of the writ petition in favor of his client. ঠিক আছে, full stop. According to Mr. Banerjee, the court should restrain itself in framing the questions / issues founded upon the facts pleaded in the writ petition, but should decide the issue of maintainability at the first. We had an occasion to peruse the the tenet of the orders passed on the aforesaid dates, we do not find any reflection of impinging upon the right of either of the parties, nor we could persuade ourselves to agree with the stand of Mr. Banerjee that there is any interim order or the protection passed or given in favor of either of the litigants. It transpires that the court, after due application of mind, expressed his view on the issues which may have some impact in the said writ petition, and to avoid any surprise to the appearing counsels, such questions / issues are recorded in the aforesaid orders. It is not a case decided where right of any of the parties is affected, but a mere recollections of the issues / points which emerged in course of the hearing. Stop. Both the parties or their respective counsels are made aware of such points or issues, so that the court may be in a position to get the adequate and meaningful assistance from the bar in pursuit of rendering the justice to the litigants. Had it been a case that an interim order is passed, the stand taken by Mr. Banerjee have a substance, so even a Supreme Court in PM Ramalingam Supra, as relied upon by Mr. Banerjee, in unequivocal terms, held that the moment the plea of maintainability of the proceeding is raised, it would be proper for the court to decide the same first before it ventured to decide the issues on merit. The judgment of the apex court appears to have been misplaced in the context of the instant case, as in the said report, the plea of maintainability was raised, but the court kept the said point to be decided at a later stage of the proceeding, and proceeded to pass an interim order of status quo, which would entitle the respondent therein to enjoy the benefits of the conditional promotion as well as the benefit of 3 years of extra service. Stop. In the backdrop of the aforesaid fact, the apex court in paragraph 9 of the said report held that the High Court could not have passed the interim order, which virtually means allowing the review petition without deciding the question of maintainability of the review petition. The judgment rendered in a case is decided on the facts or the facts involved therein. The ratio has to be called out from the observations made in the context and not to be ascertained in isolation thereof. As indicated above, there is no interim order passed by the single bench in the impugned orders, and therefore the judgment relied upon by Mr. Banerjee has no manner of application in the history. Taking a clue from the ratio of law laid down in the said judgment. It is the ardent duty of the court to decide the maintainability points at the threshold and should not embark his journey by passing the interim orders. Virtually affecting the rights of the parties. We are informed in course of the hearing. In course of the hearing, we are informed that in a subsequent order passed in the said proceeding, the court of first instance have expressly indicated that the point of maintainability could be taken first, and which, in our opinion, took care of the questions raised by the appellant in the instant appeal. We hope and trust that the point of maintainability shall be decided by the court of first instance, as and when the same is raised or the occasion to decide the same arise. Before delving upon to decide the issues on merit or to pass any interim order in the instrument. The appeals are thus disposed of, connected applications are also
Published.
The section 3 may be allowed.
So the staff reporter had opined that there is no delay in filing the instant appeal, but upon going through the record, we find that such report is incorrect.
আরে যেটাই দিয়েছে সেই অর্ডার চ্যালেঞ্জ করে দিই
The learned advocates have also accepted that there is a delay in filing the instant appeal and have taken out the instant application for continuation thereof for hearing the counsels and after going through the amendments made in the said application, we find that the applicant was prevented by sufficient cause in not filing the appeal in the period of limitation, provided therefore the application is allowed, the delay in filing the appeal is hereby condoned.
My lord, subject to correction, can I submit one thing, my lord? Since subject to correction on consent, the appeal is taken up, since memo of appeal has also been disposed of.
What provision the memo of appeal is to be disposed of?
My lord, I heard the memo of appeal has been subject to correction. I thought the memo of appeal has been disposed.
Never come across in my life, both on that side and this
Appeal.
side, the memo of appeal has been
Memorandum of appeal. Appeal.
memorandum of appeal also. to be disposed of.
Appeal is disposed.
That is what we have done.
Yes.
Thanks.
Under Order 41, Rule 11, Rule 1, it is the procedure, the form that it should be done in a memorandum. Nothing more than that. It's a registration. In a suit, when the suit is disposed of, one has to write the plaintiff is disposed of. Unheard of, sir. I was surprised when I will convey to your senior.
No, my lord, kind.
Convey to your senior.
My lord, kind.
I will convey.
Obliged, my lord.
All disposed.
29.
Lordship, I appear on behalf of the state, your lordship.
Appeal for the respondent number 2, Lordship.
Your lordship.
Lordship, for the appellant, this is the affidavit of service, but your lordship, there is a delay of 3 days.
Your lordship.
We have not served the copy of the condonation of delay on.
Give it here and now.
Your lordship.
Have the spare copy.
Lordship, I have, but I exhausted with 2 and 3. 1 and 4, I could not.
Spare copy.
I do not have as of now.
What are you doing?
Bullshit. Your lordship.
Lordship, kindly see, memorandum of appeal, Lordship. The respondent number 4 and 5 is not made as party in the writ petition, Lordship.
They have subsequently they have been made a party. There was an earlier decree granted by the court.
Yes, your lordship.
It has been done.
Yes, your lordship.
You are entitled to a copy.
Yes, they have not served a copy.
So you should come with a spare copy.
Sure.
You could have disposed of your application here and now.
So your lordship,
I think they will not oppose for
the delay, your lordship, 3 days of delay.
So I say they will not oppose, but they are entitled to a copy.
No.
My copy, your lordship, I do not. Lordship, the private respondent could not be a party because I'm told that because he was not a party, pleaded in the main writ petition.
It was not a party.
Not a party.
And 4 also, Lordship. 4 and 5 both, Lordship.
4 and 5 both were not parties to the writ petition.
Lordship, kindly see the memorandum of appeal, the first title.
Yes, the respondent number 4 and 5, subdivisional officer and Debraj Vishwas.
No. That has been scored up. Still, in 4, one public information officer has been increased.
Lordship.
5, there is no incorporation. There is no 5.
No, your lordship.
Yes, no.
They wrongly implicated sub-divisional officer. That was scored. His name was deleted. And in his place, the public information officer has.
Lordship.
Yes.
So, regularize.
But the private respondent was not made up.
Course of this day.
Section 5 application, I have given it to 2 and
Give a copy because you don't have a copy.
Lordship. Fresh copy I am not carrying
He
today.
will give you a copy today. He will give you a copy.
Okay.
Or you get it photocopy, then give it.
Okay.
This is an application for confirmation of delay of 3 days in preferring the after perusing the government's metering the instant application. And upon getting the respective concepts, we are satisfied that the system was prevented by sufficient cause in not provided them. The application was allowed, the filing is controlled. Let the application for stay be listed on Monday.
Monday.
Your Lordship,
Sure that a copy of
Your Lordship, on Monday, due to some personal difficulty, I won't be available. Your Lordship, kindly take it out to Tuesday, Your Lordship.
Tuesday.
Grateful, Your Lordship.
Affidavit of service file. Give your name.
Order number 30.
Number 10. Service. Can you Pashi
Sir,
In item number 30, I am appearing for the appellant. Sir, on last occasion, your lordship has directed to serve a notice upon the government leader. That has been served, Maladi. There is someone who has been assigned by the government leader, but but till today nobody appeared in this matter. The name I have collected from the GP office. Thereafter, I have served a notice upon that particular advocate.
Sarkar advocate.
But he never appeared in this matter.
One Prosenjit Giri, who is he?
He is the clerk of that lawyer.
The matter.
The matter is regarding the interest on delay. Can to matter. There is only one can, that is for the appropriate order. And there is another one, there is section 5. Section 5 has already been allowed, madam.
Order is can to.
Can to, madam.
What is that appropriate order?
Appropriate order, madam, that is for making.
Where are people? You are allowing this.
Right. May I submit one thing? I have been covered by one of the by judgment of single bench, my lord. May I, last day, my lord, I have shown it to your lordship. May I,
You have paid for a direction to prepare a paper book. We are
can to. My lord, the issue is very short, my lord.
Sorry.
the side. No.
Yes, madam.
You have to bring the other side.
I have served upon the.
Then we are allowing this.
Okay, my lord. You keep it next week, my lord. I will again serve a notice upon the other side, and I will bring. I will try to bring him. I don't know whether he will appear or not. Because, my lord, the issue has already been decided by the single bench, my lord.
Then we are allowing your prayer for can to.
Okay, my lord. Next week I will bring that.
ওটা ক্যান টুটা লিখে দিতে হবে আর আবার
31.
other side. I'm not some. Hey, alone.
But nowadays there might since there is a resolution.
Today is a special day. We take up
No,
Passover,
on Monday, my lord.
not this week.
32.
32, my lord, I am appearing for the appellant, my lord. I am coming up against an order of 16th January 2024 by which my transfer prayer was rejected. My prayer for transfer was attributed to the reason of serious gynecological disorders. The medical documents I have annexed. I am relying on that 2015 rule of general transfer rules as amended. Rule 4, Rule 4, A subclause 1 and Rule 6 also.
Kindly turns to page
2021 amendment.
47 once. 47.
My lord, I am extremely,
Recommendation was already, my lord. Yes.
I am extreme.
Yes.
Begin. Don't hijack.
But first, my lord, I tender my apology, my lord. I have not annexed the order with the stay petition. My lords have to look to the memo.
I'm more comfortable to come.
My lord, my lord.
We never look at that's a candid confession.
But
Even if somebody refers 125,
it has been rejected on the ground of non-availability of PTR. No, I made a representation that was never considered.
application is made, that's all.
Yes, thereafter that was never considered, and I came up before the
We did offline or online.
offline. Yes, my lord, that is at page 81 of the stay petition. Life science.
Of two of medical ground. What is this? What subject you teach?
Life science. Class 9, 10.
School Service Commission. For headmaster or headmistress.
My lord, in that event, my lord, kindly give me liberty to do that at least. And my lord, rule 4 and rule 6, my lord, is in, I have a right
Yes,
under
he was
that.
appointed through the selection process of 2016, my lord. And my lord, which the entire selection process was already set aside by the
Yes. They we have said. Then we will keep it
signature
sign. The fixed spot is
on 16th, my
On
lord.
16th, the matter is fixed.
don't have it. So service goes, then what remains transfer? Then you remain in your home.
Actual sign it. I'm grateful.
Item number 34. I am for the primary school council.
34 mal RAM for that.
There is a similar appeal from the same impute order.
Similar appeal.
From the same impute order, preferred an appeal, my lord.
What? This matter? You have not seen the matter as yet.
But page 253 of the
Just first go through the impute.
253 of the stay application is the impugner.
Always look at the one. Why you have come?
We at the prime assistant teachers having
Say the justice to identify those institutions
my only grievance is that similarly situated candidates
that we wanted.
the similarly situated candidates who
They have raised an issue similarly. The court has not really gone into it.
my
Whether you are paying, who is appearing for the board of the school?
board
Lord, I appear for the West Bengal Board of Primary Education.
Paying,
Lord, we don't pay.
case.
Pays state.
State is appearing.
but it has been served
Category A scale of pay, whether the
kindly see one document page 229
though the service have been affected upon the states, yet there is no representation at the time when the instant appeal was moved. After perusal of the impute order, we find that two issues were raised by the writ petitioner / appellant before the single bench. One in relation to undergoing the bridge courts, as there was not a single institution within the state.
I'm late by mistake.
And second, similarly circumstanced teachers are still getting A category pay scale without undergoing the bridge course from the recognized institution. There is no reflection in the impute order so far as the second issue is concerned. The council for the board as well as your for
I was the district primary school council.
primary school council. You do want to submit that the payment of a salary is within the exclusive domain of the state.
Yes.
In view of the above, the state is directed to submit a report whether the similarly circumstanced candidate, the teachers within the state
or three categories scale of pay, despite having not undergone the bridge course from a recognized the institution of the NCT.
It should be NCTE. Yes.
Is the matter on next Wednesday.
But perhaps my Wednesday is a holiday, my lord, due to Moharram, my lord. 17th.
Then the counsel for the appellant is directed to communicate this matter to the Advocate General, learned Advocate General, as well as the learned government leader by tomorrow.
Next Thursday.
Holiday.
holiday.
It's Shakir. Sorry, let me come. I have a bad habit, sir. And it's a sorted state of affair. I tell you very frankly, not meaning to any of you, but collectively as a member of the bar. I had the strongest of feeling on the statement made at the bar. And I always treated as sacrosanct because I was there for a pretty long time. I know what the bar was. And I never looked up the papers. The moment they say, I take it that it is correct. But such trust was misused in many ways. Since then, please do not take it evening anybody. Since then I decided that unless I look at the paper, I will not do it. So we say we are not disputing that what you say is correct, but still we will look at the paper. Whatever it will appear, then we will see. Really painful to me, I tell you, because I still feel on that side. The genes are on that side, but there are at least 5 instances.
We also get misled on facts at certain point of time.
And absolutely,
while reading the papers,
was said, led me to believe, and later on proved to be wrong.
Lies were said.
At the time of reading the papers, we get to know something which is just contrary to what was said in conference. That's also, that's a bad experience that we all have.
No, no, it is painful to me because I never believe. I always have that relation. Because I believe that the member of the bar always argues on the basis of the facts pleaded therein. They will never argue something which is outside the field. That's my firm belief. Anyhow, your paper will come and then we'll see. If it is same.
Not in fact, not in this case, it's recorded in the Honorable Supreme Court's order that the course is yet to be designed. So
let them come and say it's a case of discrimination.
না ওইভাবে বড় স্লিপ না বড় স্লিপে দেবে 35.
I'm for the board, Lordship.
পুরুলিয়া ভাস্কর দা
I'm challenging the order dated 22nd April 2020.
Fargo of 5 years.
Lordship, the 5 years has been replaced as 7 years in the amendment.
Malad, I specifically state that yes,
Lordship, I have a notification.
Yes. Malad, this is the West Bengal. Malad, I'm giving the 2 books to your lordship.
they have given me one compilation.
West Bengal primary education, transfer of teacher, including head teacher, 2002, Lordship.
West Bengal School Service Commission, General Transfer.
West Bengal primary education.
Malad, your lordship, I have two books, man. Your lordship.
Any one of you,
Yes,
a compilation. Somebody gave a compilation. It is easy for us.
Lordship, that may be for upper primary, but this is primary.
Oita cold. Oita cold. Your lordship, first malad, your lordship come.
This is the ground bar of transfer.
Lordship.
6.
Rule 6, Lordship.
For transfer for a period of time from the date of the transfer.
Your lordship file firstly come to sort title and application. Rule 1 of the malad said rules. Rule 1, malad. Rule 1, malad.
Want to go in a different jurisdiction of the council?
Yes.
Lordship.
Yes, ma'am.
Lordship.
Yes, ma'am.
Into another district.
How this rule applies. If it is within the zone of the council, one council, then it is that is applicable.
Yes, my lord. That is my ground.
Beyond zone of the council, then look at sub-rule 2 of rule 1, sub-rule 2 of rule 1. These rules shall apply to a teachers, including the head teachers, for the purpose of transfer from one primary school to another within the jurisdiction of the council. So outside the zone of the council, if they want, this rule does not apply.
But Lordship,
This inter is inter.
Yes, ma'am.
No, he is asking for inter.
No,
not
no.
Intra.
I am asking for inter-district.
Inter.
And my lord, these rules meant.
No,
I am
Lordship is telling
one
for
district
intra within the district.
Your lordship, these rules for intra-district. And I am asking for inter-district. From Coach Bihar to Purulia. And my lord,
Wanted from one zone to another zone. That is what?
yes,
From
ma'am.
One district, Lordship. Different,
Coach Bihar to Coach Bihar to Purulia.
different district.
So how this rule applies? But take shelter under this.
And my lord, for
What applies?
my lord, applies your lordship, then come to page 156 of that book. 156. I have marked it. 156. Principles and procedure for transfer of teacher or non-teaching staff in a primary school between two primary.
Is there any?
It was framed. It was framed. These rules. Yes, ma'am.
I am asking a question now.
Yes.
Is there any rule relating to this inter-council transfer?
Yes, ma'am. This is the procedure.
No, not a rule.
No, my lord. This was made on the basis of, my lord, your lordship kindly see that rules, 2002 rules, there is a section 8. Section 8 says that it is upon the board who can make the procedure. Section 8, my lord, your lordship kindly come to the earlier rules which have your lordship there is a section 8. Inter-council transfer. Your lordship got it. Well, may I read?
Just wanted where is the act?
Yes, madam. Then your lordship kindly come to page marking.
Where is the West Bengal Primary Education Act?
Yes, madam. 19(1)(k). I have been also page mark that portion, madam. Your lordship kindly see the another flag mark there. Page 20 of this. May I read out? Okay. This is the power and function of the board.
Where is the principle?
Now, your lordship, kindly see the procedure or the principle laid down by the board. That is, my lord, your lordship got 156 of that page. Of that book.
Wanted the paragraph 5.
Yes, ma'am. Yes, ma'am. Your lordship kindly got it. This procedure, principles and procedure.
Got it.
Yes, ma'am.
Which is the procedure. So it
Yes, ma'am.
it has to be
There is
processed
no.
in this manner.
Yes, ma'am.
It has to be processed in this manner.
Yes, my lord. There is no bar of, my lord.
Have you applied before the
Yes,
court?
yes, ma'am. That is, my lord, my annexure at page 33 of your lordship.
Yes, who is appearing for the board?
I am appearing for the board, Lordship.
Have to decide it. And you have taken that plea of 5 years.
Lordship, that plea was taken in other matters also. So Lordship was in
No, I think that plea there. This matter.
Lordship for general transfer. We are taking pleas for 5 years, and that has been converted to 7 years, Lordship.
Yes, my lord. My
That my learned friend has mentioned in the trial court. Lordship kindly mentioned that intra and
There is no reflection of any provisions putting restrictions and or embargo of 5 years in seeking transfer. Yet it can be reasonably inferred that what weight to the single bench
my lord, only one thing before your lordship dictating
was Rule 6 of the West Bengal Primary Education within bracket transfer of teachers, including head teacher, bracket close rules 2002. The said rules, the rule 6 of the said rules is explicit that no teacher shall be eligible to apply for transfer for a period of 5 years from the date of the transfer, which according to the learned advocate appearing for the board is extended to 7 years.
Lordship, that is by notification, that extension.
Whatever, sir, extended to, we are not disputing it.
Lordship.
Such being an undisputed facts discerned in course of the hearing, the first and foremost point which arose before us, whether such rule has any manner of applicability in the facts of the instant case. The said rule is promulgated in exercise of powers conferred under subsection 1 and clause K of subsection 2 of section 106 of the West Bengal Primary Education Act. Containing the exhaustive provision relating to the transfer of teachers, including the head teachers. Stop. Subsection 1, subrule 2 of rule 1 of the said rule clearly indicates that the said rule shall apply to teachers including head teacher, for the purpose of transfer from one primary school to another within the jurisdiction of a council. It is explicit from the aforesaid provisions that the aforesaid rule has its applicability to a transfer from one primary school to another within the territorial jurisdiction of the respective primary school council.
District Primary School Council. Lordship. We pronounce it like that.
Primary school council and does not expand his horizon to a case of transfer from one territorial jurisdiction of a council to another territorial jurisdiction of a council. The aforesaid provision appears to have been overlooked. Had those been brought to the notice of the single bench, probably the said order would not have been passed. It is no longer a cetegra that the moment the subordinate legislature or the substantive legislation is promulgated to operate within a limited contour, its operation cannot transgress such limit, but have its applicability within such limited sphere. The stand of the board, stand of the council, that an embargo of 5 or 7 years are created in processing an application does not appear to be in consonance with the law applicable in this regard. Our attention is drawn to Section 19, subsection 1, clause small k, within bracket, small k of the West Bengal
Code of Primary Education Act 19.
Education Act 1973. Being the repository of the powers and the functions of the board, including the power to transfer any teacher or non-teaching staff from a primary school within the jurisdiction of one primary school council to a primary school within the jurisdiction of another primary school council. Such power vested upon the board in case the transfer is sought from one zone to another, or in other words, from one primary school council to another primary school council. And therefore, in such situation, the primary school, the respective primary school councils does not have any power or the jurisdiction to deal with an application for transfer, or deal with such application for transfer. The executive instructions in the form of a principles and procedure to process the said application is also subsequently framed by the secretary of the board it a notification number 230/91-92 on 2nd November 1991. It contains an exhaustive provision relating to an application, relating to the principles and the procedures to be adopted in an application taken out by a teaching or non-teaching staff of a primary school seeking transfer from the school situated within the jurisdiction of one primary school council to a school situated within the jurisdiction of another primary school council.
But only one thing.
It does not contain any embargo like the one appearing in the set rules. And therefore, therefore the order challenged in the assailed in the instant appeal based upon the set rules, which lacks its applicability to the facts of the instant case, is unsustainable. The impugned order is thus set aside. The board is directed to the secretary or more.
Secretary of the board, Lordship.
Secretary of the
board is directed to consider the said application in the light of the said notification dated 2nd November 1991, and a conscious decision shall be taken within 4 weeks from the date of the communication.
Only one thing, my lord, may I add? Because, my lord, there is an amendment in respect of 2002 rules. There is a clause, my lords, in respect inter-school transfer. Inter-school transfer, they have only made Rule 5.3 of this amendment rule will be taken into consideration. That part, your lordship kindly, my lord, your lordship kindly take this amendment.
That will not be there.
This is also a amendment of two. I have given two দুটো দিয়েছি একটা The lordship also sees that there is no bar in respect of Rule 5.3. Yes, my lord. That's why. That's it. My lord, no, my lord. I am not. What is arguing? My lord, what is arguing before the single bench that these rules only applicable and my lord this amendment. So my lord, no transfer.
Kindly add one thing, Lordship. As per applicable rules, as because Lordship, people teacher.
আরে ওখানে পিপল টিচার রেশিও লাগে না
বাবা আমি দেখবো না আমার টিচার জেনারেল ট্রান্সফার হচ্ছে শর্ট হয়ে গেল তখন শর্ট পড়ে গেলে কি হবে
আমার বইগুলো একটু দেবেন না প্রায় সব একটা বই দিয়ে দিয়ে দেবো
গ্রেটফুল লর্ডশিপ শুনলি না কি লেখা বললো তো করি জিজ্ঞেস করে লাস্ট ওয়ার্ডটা কি গ্রেটফুল
আমাদের বই তো ওইখানে
Item number 36 250.
Lord, I 36 to 50, my lord, I appear for the appellant. My lord, by the impugned judgment, which is dated 9th August 2019,
my lord, as many as 116 writ petitions, they were decided on merits. Writ petition dismissed. Out of 116 writ petitioners, 76 independent mandamus appeals were filed. 37 chose not to file appeal. My lord, out of 79 independent appeals, 15 are listed today. 64 are not listed. My lord, what happened was this: in the second matter, which is item 37, my lord, the stay was served on the other side. My lord, the paper books were directed to be filed. My lord, the things are complete. So far as the other 14 appeals listed today are concerned, my lord, the service is not complete. I must say this, my lord, very candidly at the outset. My lord, this pertains to the 2006 recruitment, 9 recruitment process, where, my lord, in terms of the then recruitment rules of 2001, which, my lord, gave a premium only in terms of sponsorship to trained candidates and not so far as empanelment is concerned. My lord, what this district primary school council Howrah Hooghly did was they prepared a separate, my lord, panel of trained candidates, which is not contemplated in the recruitment rules, and these trained candidates got lesser marks than us, and they were appointed.
Eligibility criteria for this, or whether any preference is to be given.
Preference in terms of sponsorship, and that has been held. My lord, I rely.
You heard. Who is appearing?
My lord,
I wanted from
my lord,
the other side, because it will be representing all the writ petitioners.
Yes.
my lord, Mr.
There would be a multiple persons from
Yes.
the respondent side. I wanted 1 or 2 persons to argue.
My lord,
One named parties first.
Mr.
My lord, I will be seeking.
Oh, there are private respondents as well.
Yes.
Are they served?
My lord, so far as the second item is concerned, they are served.
About the others? But these persons, the same person.
Same persons in all writ petitions.
Who is appearing for them? Who is appearing for them?
My lord, from the honorable single bench stage, nobody.
They are not appearing. Even
Nowhere.
here
No. My lord, I will be relying.
don't rely. Let us first
Yes.
make it ready so that one day you exhaust and we will decide all the matter.
Yes.
Now you are for
The appellant.
this for the state. Let me.
My lord, in 37, my lord, my lord,
Anybody who is appearing.
my lord, I am appearing with led by Tapan Kumar.
Tell me just.
State, my lord.
I don't want.
My lord, state.
It's appearing for the primary school council.
Mr. Bishobroto Boshumolli.
Where is he?
My lord, Mr. Boshumoli is
He appears for Hooghly.
Yes.
my lord, but he is engaged on football.
Yes.
2 persons. You are. When
My lord,
when
this
pick up one matter which is there, paper book. Tell us when. And you and Mr. What do you say?
Boshumoli.
Mr. Bishobroto Boshumolli.
For the council. In all
my
the
lord, my lord, keep it on the next week, my lord. We will. In next week, my lord.
37.
I'm in 37.
Ready.
Yes.
Paper book given.
Yes.
এটা কি 37 এর paper book? Yes, my lord, 37 paper.
Next week when?
Next week.
Next Wednesday, my lord. Next Wednesday.
If you come, I will come.
Oh.
Rather we will come. No difficult.
17. My lord, then
I will
Thursday.
stay on Saturday also. If you come.
But most of us are not.
No, I know that, but my lord, Mr. Mukherjee rang me up and told that they are going to hold court in Saturday. When we will prepare ourselves. So much.
Then I must flag it because I am a part of that.
Yes, madam.
Yeah. Difficulty is that the entire country, they are now increasing the number of working days in the court. And there is census which has arrived is that instead of 210 days, I court should function at 20 days. The Supreme Court has also increased considerably. This time, instead of this skeleton vacation bench, Supreme Court has given a full-fledged bench. You have seen very recently the news came, the disposal was enormous during the vacation. So what I propose is that I know the pulse of the bar, that if we curtail any of the longer vacation, you will have some. If we curtail any of the already notified vacations, you will have a problem. The best course, which I believe is a very one Saturday in a month, it is not every Saturday. Any Saturday within a month.
Within a month.
We can spare one Saturday in a month. Then we can have 12 Saturdays working. So from 210, we can
222.
220. Any Saturday in the month. We are not saying every Saturday. That is a very fair proposal that should. After all, we can't shy away. We have to increase.
That too, my lord.
We are not saying first, third, fourth, whatever. Whatever that is. Sometimes it so happened that the first Saturday, before that, the Thursday is a holiday. The Friday or the Friday is a holiday. So we will not work on Saturday because the continuity. So it is left any Saturday in a month. It may be first, it may be fourth, it may be second, it may be fifth, any Saturday in a month. 12 Saturdays, 12 working days, 220 days. That was my suggestion. You have to work 220 days. And you remember, the days have come. It's not me. After your generation, the younger ones, they are very much interested in doing. The work culture should change. When you will prepare, everybody knows in a time you prepare.
The
writ also it should happen. One Saturday can be suited. Going in the mufassils and doing a lot of the things is known to me. Therefore, I see yes. So I know everything. What happens on Saturday? Preparation, another preparation.
আমি কি বলবো ডিপিএসসি
On next
Thursday week.
Thursday week.
কোথায় 18 মানে from Lord 15 16 17 18 19 in that entire week I will not come for my personal reason. After 21st, any date, Lordship. No, Lordship, I am telling after 21st, Lordship.
Because then we can fix it on 25th.
Lordship.
All the bunch of the are aimed against a common order. And it appears that one of such appeals, after
FM 444 2021.
the services company and the paperwork has also been filed and circulated upon the appearing counsels. It is informed to us that the private respondents either appeared in the writ court and neither appeared before the single bench, nor
37 শুধু আমার পেপার
appeared before us.
আছে আমারও তাই
Before this court.
এগুলো
Be that as it may, the issues involved in the aforesaid appeals needs the presence of statutory count, the authorities, namely the board,
No.
from other states. Board is party.
No, council and state.
And the district primary
School council.
Yes. Who are represented before us. In order to avoid the prolixity of repetition of argument, as several councils have been engaged to represent the state as well as the board, as well as the council, we therefore permit the councils appearing for the aforesaid respective parties, authorities, in item number 37, to argue the matter. However, it is open to any other councils if they have any other point not argued by the councils appearing in the said madam's appeal to make the submissions at the time of why to shut their right. On the consent of the appearing councils, let this matter be discussed on 25th July to be taken up as is specified from the beginning.
Yes, sir. Just after to be mentioned.
The list of the other 16 more appeals.
বাকি লিস্টটা দিয়ে দাও
Lordship, I will hand over the other matters.
চৌষট্টিটা
The private respondent under, they are serving under the council, elected the council to get the information.
Why are you Millard? Let him do the formalities. Let him do something, Millard. Why Mr. Mishra is avoiding?
You are very kind-hearted man. You always think that all the persons should come and participate in the proceedings. Go unrepresented. That's a very kindness on his part. And you are taking an exception.
No, I have not taken exception. I have said, Millard, let
Everybody to participate in this. That will not only help that litigant, but also beneficial to some of the members of the bunch.
তুমি তো সব জায়গাতে ডেটে আসো কেন বলতো সব জায়গাতে ডেট মিস্টার মুখার্জি at least
It's called the next.
Item number 51 to 53.
My lord, I am appearing for the appellants. On 24th of June, the matter was dismissed for default due to our non-appearance, my lord. My lord, it has already been served prior to filing, my lord, upon this date. Now, my lord, this is that matter, my lord, that criminal appeal, my lord, that Mujahid Khan. My lord, on that day, my lord, I mentioned this matter. My lord had asked me to write.
You have already signed the order. So what can be done?
As praying for restoration of the recalling the order.
Have you served the state?
My lord, it has been served, my lord. Notice, my lord, with the petition. Because now it is all are the state copy and the petitions are filed to ফাইল হয়
To bring who appeared, Mr.
মিস্টার সুদীপ ঘোষ and মিস্টার মধুসূদন my lord,
An application for restoration of the instant appeal which was dismissed for default on 24th. After there is no representation on behalf of the state respondent. Despite service having effected on 27/6/2020. The benefit of the amendments made in the application as well as submission by the we are satisfied that the applicant was prevented by a submission for the not appearing on the meeting when the said applicant was called on and dismissed for the order dated 24/6/2024 is hereby recalled. The appeal is restored to its original file and number. Let the appeal be listed on August. The counsel for the applicant is directed to communicate this order to the counsel representing the state. Immediately.
my lord, as earlier mentioned by myself, my lord has asked me to write a letter to the Chief Justice relating constitution of bench of my lord, Justice Tandon and my lord Justice Prasad.
We have seen only for your reason this could not be. Otherwise, it would have
Because Mr. Mukherjee has undergone surgery, my lord.
that if it is
And we'll
done,
come back on 5th, my lord.
if it is done, then we can. Otherwise, we no work. Administrative. Position would have been different.
No, big, there are 4 matters, my lord, that matter, my lord. Can lordship taken up this matter on 25th, my lord? When 120 is here, my lord, formalities of.
Tomorrow. I don't think so. Any matter is big.
No, my lord. Is before his lordship, nothing. That I know.
I have no.
No, my lord, I have it. No, my lord. Yes, all matters are equal. No, I'm
But since there are 7 paper books, that's why my learned senior friend is saying.
Both there and here is more the voluminous papers, less the legal point it contains.
Yes.
Issue is very small, my lord. Issue is very small.
Yes. So if lordship subject to his lordship.
When?
But that's 25th lordship. That matter has fixed this matter also.
25th
lordship. Get